Good morning, everyone. I hope everyone had a good evening and the homework wasn't too tough. Might still be worked on, but I know I've been in that position many times myself when you've got key matters being worked on sort of between hearing sessions. So I know that's it's always a bit challenging, but here we are. Just to let everyone know that David is struggling a bit. He is staying on the end of the wall, listening in, and just preparing a forum. We has to sort of fill in, but I'll be leading the questioning, and David will do any sort of roundup at the end, either bouncing off me or asking any questions he has. So that's the way we'll work today. So,
Giving you a thumbs up.
oh, I know for those that haven't met David, yeah, he's got a great sense of humour. So thanks for that, David. We'll be back with you, starting with your scope discussion.
Yes, thank you. Can I just outline that I've had a quick discussion with Mr. Nolan this morning? The thinking there is that I'll finish my legal subs. We'll have Mr. Dingle's evidence, and at that stage, I think we'll inject Ms. Hooper back into the process to bring you up to speed with her overnight. We'll get to Ms. Carter.
Yeah, that's ideal.
Okay.
Is my speaker on? Yeah. Right.
So I was up to page 8 in my legal subs at the topic of scope, and maybe just before I go there, it might help if I say I don't perceive that there is much material disagreement about the legal principles that apply. I think the principles that my friends have referred you to, or Seaport, the principles that I'm referring you to, and the principles that are being referred to in the submissions you've had from counsel's lawyer are all actually agreed. There's no dispute about any of that. The dispute arises, of course, when you come to try to apply those principles to the facts of the case, and obviously I'll elaborate on that. But I say that up front because I want to make plain that I think reviewing the cases can be somewhat instructive in terms of understanding what the principles are, but that's really as far as it goes, because the facts do tend to all get decided, the cases all do tend to get decided on their facts. And I think there aren't really any cases that I see in the cases that we've all referred to that are directly comparable to the situation in front of you. So you do need to apply the principles in a new way, perhaps here. And maybe actually can I take you to the Albany decision, because it's useful if I just identify that it is in that bundle of materials that I've handed up, and I think Commissioner McMahon has these electronically now.
Thanks for Christine that came through this morning, David, so we've all got the same information.
So in the hard copy, it's behind tab 1, and I should say straight up, it's obviously not the full decision. The full decision is very long, but I just wanted to take you to paragraph 101 to begin with. This is where the assessment on the scope issue begins, and quite properly, Justice Futter begins with the question of scope raises 2 related issues, legality and fairness, and at the bottom of that paragraph, the second issue of fairness is about whether affected persons have been deprived of the right to be heard. And I think that is front and centre in terms of the issue that the Port is raising here. Then if we can skip to paragraph 110, I just wanted to emphasise here that Justice Futter's decision reflects what I take to be relatively uncontroversial. Participation by the public and district and regional plan processes is a long-standing policy of the RMA, and the first scheduled process envisages an opportunity for participation by affected persons. And I say that only really because there is a passage in the text of the Motiti case that is in my friend's submissions that I find somewhat difficult to understand in terms of what it's saying about limited participation. And I say Justice Futter's statement here is consistent with a long line of authority, of course, about public participation. And I can come to that extract from Moteti in due course. But I just wanted to make sure that it was clear that, in my view, there is no watering down of that public participation policy in this setting. And then the final one that I think is useful, just to identify the next page at 115, 116. That's the passage that you've heard before, and I won't take you through that. No one is disputing that sets out the orthodox positions in relation to scope. But I thought it might be useful to take you right to the end of the section that I've included, and that's at paragraph 175. The reason I'm taking you here is because this is a passage in the judgment where a question was really being examined about whether, to what extent, it's appropriate to put yourself in the shoes of this hypothetical person when you're undertaking these kinds of scope assessments. And you'll see at 175, Justice Futter is recording something that was said in the Countdown case, and this is halfway through the paragraph. Countdown cautioned about the danger of substituting a test which relies solely upon the court endeavouring to ascertain the mind or appreciation of a hypothetical person. So he's describing what Countdown said, and I won't take you through the quote that follows on from that, but I will take you to what Justice Futter's view is, because I maintain it's the right position, and that's at 176. He says, I think it is preferable when dealing with a planning process of the present scale to be cautious about the extent to which affected persons are fairly on notice of potential changes that might substantially change, for example, their residential amenity. To that extent, I prefer to approach the assessment employing a test based on what might be expected of a reasonable person in the community at large, genuinely interested in the implications of the unitary plan for him or her. It is the type of assessment that judges must regularly make on behalf of the community in resource management matters. And it won't surprise you to hear me say that really, I think, sets the lens that you need to be applying here. A reasonable person in the community at large, genuinely interested in the implications for them. So that's all I wanted to take you to in Albany, and I don't see in any of my friends' submissions or the council's submissions any real disagreements that that's the approach that needs to be applied. I'll then go to paragraph 32 of my written submissions, and I don't need to repeat what's said there. 33, for the reasons that follow, I submit there is no scope for the outcomes that Seaport is seeking. Seaport's submission was filed in November 2019, and at that time, Seaport had not developed any of the bespoke provisions that it now seeks to introduce. Its submission explicitly identified two outcomes. Outcome one is in the following paragraph, and I won't read that to you, but I draw to your attention the words in the first line, within the Port MFZ, and the corresponding relief, I'm at paragraph 36, was expressed in this way: seventh area within the Port MFZ be added to cover the cool stores site, and so on. Now, the reason I'm drawing those two passages to your attention is they both seem to be addressing the same thing with that reference within the Port MFZ. Retention of the port zoning, but asking for addition of a new area, i.e. a sub-precinct, to add to the 6 sub-precincts that comprise the port zone as notified. The new area, sub-precinct, and I don't think it makes a difference what you call it of those two, would specifically address Seaport's aspirations for its site. Seaport's stated preference for this outcome being, as it said in its submission, the most appropriate way to proceed, has changed. This outcome one, has been altogether abandoned. And by that I mean Seaport no longer seeks to retain the port zoning for the site at all. I say on that basis, it is therefore necessary to look closely at the passages in Seaport's original submission that relate to its alternative outcome, because that is where you need to look to find the scope. there are potentially 3 of those passages, and I don't want to make it seem that I am ignoring the very important section in Seaport's submission that sets up the issue, the background section that says we don't want port zoning, or we don't want this zoning, I should say. I don't deny that that is very plainly expressed in the submission. And there is, of course, a background section at the front end of the submission that does a lot of the work there and references the consent process that Seaport had by then commenced. But I still say that when it comes to looking at what was it asking for, it does seem to be these 3 passages that I'm going to take you to, where we must find some way to house what the outcome is now within these. So the first of these passages is paragraph 13. It says, the alternative for this land is to remove it from the Port MFZ and place it within the district-wide zoning framework. This would need different consideration throughout the site to reflect the zones required. And I just make 2 observations about that. First of all, it doesn't say in that passage what zone would be applied. It just says within the district-wide zoning framework. And the second observation, in the second sentence, it uses the word zones, plural, not singular, which perhaps creates a suggestion that there could be more than one zone, or that one might draw from different zones within the existing district plan framework in order to come up with something. Second passage is at paragraph 18 of the submission. It says that NPDC go back to the drawing board on the policies, rules and objectives for the Port MFZ. NPDC must consult with Ngāti Te Whiti, landowners, other interested parties within the port together and the wider community with a mind to developing a detailed, ambitious structure plan for the Port MFZ that will replace that provided in the PNPDP. Port zones are able to be vibrant, beneficial places for everyone. The port is part of our community and our community should be involved in shaping it. The third passage is from the final bullet under paragraph 19 of the submission. It's the consequential relief, any further or consequential relief as may be necessary to address the matters raised in this submission. As I've said, I say scope for what Seaport is seeking must be found in one or more of these passages, or the passages in combination. The question to be asked is, do the provisions now sought by Seaport go beyond what is fairly and reasonably and fairly raised in submissions? And there is no debate, it should be approached in a realistic, workable fashion rather than from the perspective of legal nicety. And just perhaps a word on that, there is this word holistic that gets applied in this setting. Said that the submission needs to be read holistically, and that's certainly the approach that council have taken. I don't disagree with that proposition, but I do say that reading the submission holistically, it does not mean that you don't pay attention to the actual words that are used in the submission. And I think that's probably where I would say there is somewhat of a difference emerging between my position and that of the other lawyers you're hearing from. I also note there that by the time this submission was filed, Seaport had already lodged its consent application, and as I understand it, had completed the further information that had been requested in relation to that, and it was around this time that its consent application was in fact notified. And in that context, I would say it was not beyond Seaport to provide much more detail in its submission than it chose to, because it clearly had in mind a very particular outcome for the site. It must have in order to have put together its consent application in the fashion that it had. At 44 now, the starting point is that the relevant parts of the original submission that I have quoted are not altogether clear. Paragraph 13 seems to be talking about removing the site from the port zone and in place of that applying a combination of provisions drawn from other parts of the plan, which does not seem to be the same thing that paragraph 18 is describing, paragraph 18 seems to be exhorting the council to start over with a fresh consultation and to formulate a new structure plan approach. The more significant point, however, is that whichever part of the original submission Seaport is now relying on, including the consequential relief clause, the original submission does not state a single provision to address the issues that the submission has described. There is no objective, no policy, no rule, and no other method stated in the submission. There is not even an attempt to conceptualize any such provisions by setting out the key matters that such provisions would need to address. Before I go on from there, I'd like to draw your attention to the Blue Haven matter in comparison. I've included this in the tab at 8. There's a copy of the Blue Haven submission, and it's not a full copy. What I have recreated here is the front end, which is some 6 pages long, that sets up the issues and broadly describes the outcomes sought. And then there were some 90 odd pages behind that of detailed tables. The last of those was table 3, and I've included that. And if we look at table 3, what you can see in the Blue Haven situation is an attempt to identify what the new zoning provisions would be. There's an objective stated. There are 6 policies. And then over the page, there is a clear roadmap in terms of how various defined activities defined in the district plan would be treated, whether permitted or non-complying and so on. And it goes even to the level of providing an effects standard in relation to building height. Now, I say that's an interesting example for the panel to contrast with the position it has from Seaport, because we really don't have anything akin to this in the Seaport submission. What you have in the Seaport submission is a little bit equivalent to the Blue Haven front end with nothing behind it. So I'm at 46 of my legal subs. The nearest the original submission comes to expressing anything tangible is to state that the provisions will be detailed and ambitious and will lead to a vibrant multi-use zone that enhances the natural assets presented by the coastal location, complements the existing activities that occur in the area, and will play a vital role in future tourism in the district. The vagueness and utter lack of detail in those statements stands in stark contrast to what is now proposed in Seaport's evidence. Seaport proposes 23 pages of planning provisions, including, and it may have gone up or down depending on Ms. Hooper's work overnight, including 7 new bespoke objectives, 10 new bespoke policies, and of course a plethora of rules and standards that relate to those objectives and policies. Questions of scope often require fine discretionary judgments to be made, and that might be the case here if the magnitude of change was not so great. If, for example, Seaport was now proposing to apply the plan's mixed-use zone with no new objectives, but perhaps 1 or 2 site-specific policies and a related handful of bespoke rules, then the scope evaluation would inevitably be more nuanced and balanced. And it's conceivable, I say, that the panel could reach a reasonable conclusion that there is or is not scope, depending on the nuances. The purpose of that example is to say the facts here are not even in that ballpark. Putting the legal niceties to one side, can it be said that the 23 pages of detailed planning provisions now in front of you were fairly and reasonably raised in the original submission? I say no. And I say the proposition is so self-evident that it will be demonstrably unreasonable to reach any other conclusion. Now, I've gone on from paragraph 50 to anticipate 2 potential responses Seaport might make to this. And I concede straight away, Seaport hasn't made these responses in these terms, but I will say that my understanding of the the information it has put in front of you is that these are really implied responses in some senses to the scope argument. So I am going to take you to these. First of all, it may be said that the issue was squarely raised in the original submission. And so long as each part of the now conceived planning solution can be sheeted back to that issue, then each part of that solution is within scope. I agree that a relationship of this sort, a link between the issue and the solution, is relevant to the assessment of scope, and sometimes it is determinative. In my example above, that's the example where I talked about simply bringing in the mixed-use zone with 1 or 2 policies and a handful of bespoke rules. In that example, which would involve substantially less than 23 pages of new planning provisions, that kind of linkage between the issue and the solution might be more determinative. But in situations like the present, my submission is that a link, a mere link, is simply not enough to satisfy the reasonably and fairly raised standard. And what I'm saying here is really, it's a question of scale. What we have from Seaport is a very non-specific, aspirational statement. And we've gone from that, and that's the original submission. We've gone from that to 23 pages of detailed provisions. Those provisions aren't simply uplifted from elsewhere within the district plan framework and applied to the Seaport site. They are substantially tailored and edited to provide a bespoke zoning for the Seaport site. And it's that scale of difference that breaks the link that otherwise might satisfy the scope problem.
I've been reflecting on this, and particularly, I've got to take you back a bit because I've been thinking while you've been talking. Paragraph 41.
Yep.
Where you talk about the outcome suggested in paragraph 18 of the Seaport submission.
Yes.
To me, that anticipates some form of potentially additional Schedule 1 process where the council might say, oh, this is so important, let's go back to the drawing board and maybe do a variation and notify it.
Yes.
How else through submissions and evidence that fairly be done?
I understand the question, and I think what I'm saying to you is it can't fairly be done, and that's really what Seaport is asking for. I say quite rightly described the type of procedure that would be necessary in that paragraph. It was a going back to the drawing board, and as you say, potentially a variation or something else under Schedule 1 that restarted the process in a way that allowed all potential parties with an interest to be brought into the room. But instead of that process, what has happened is Seaport's position has evolved over time, it seems, such that it's now saying, well, we've gone and done, after filing our original submission, we have engaged Warren and Marnie, who have done this significant consultative exercise and taken in these wider views of the community. And that is supposed to give you the comfort that there's no need to go back to the drawing board. I say that's not an option. Going back to the drawing board option, unfortunately, is not something that you can require be done at this point in time. You really just have this on-off switch in terms of the scope evaluation.
We have, through the course of the hearings, on the basis of submissions raising outcomes, asked the council to go back to the drawing board. And, for example, the structure plan areas, which are the immediate sort of 8 areas that the council is relying on main growth in the life of the plan. There was quite a lot of detailed submissions about various parts of those. So we have sent all the parties away to go back and look at those, do some more work even around some of the archaeology stuff and some of the, just to give us some more information. Do you think that's a, and we're late in the piece, but you're saying that's not even a possibility?
Well, look, I don't want to be closed-minded about that. I wasn't aware that was an approach that had been adopted elsewhere. My instinctive reaction to it is that could be a way of addressing the scope problem, provided it allowed for some sort of re-notification that would open the door to those parties who have an interest. The scope issue here, of course, is you're not hearing from the people who might have had the interest, and it doesn't solve that problem for the people already in the room to do more work. It goes a long way to giving you comfort about the merit of the outcome, but none of that is relevant to solving the fairness problem that others were left out of the room from the start. So I think that procedure, whatever it looked like, would have to open the door again through a re-notification.
But the procedure, well, the parties, I've got to be careful because any party can make a submission, and the site is surrounded by many parties. Some of the main parties who are interested in these sort of issues are in the room.
Agreed.
The hapu, the iwi te Atiawa,
Yes.
who have their own aspirations for this part of the world. And I suppose we're faced with, and we have economic evidence now that, hey, this will be a good thing in terms of vibrancy, vitality of the city, and yet to hear back from the council in terms of the right to reply on this. But where we've attempted to make good decisions, looking at all the evidence in front of us through the last year, in many cases, I suppose the fundamental disagreements between the ones that have submitted have been resolved through what I observe is very good collegial planning practice. And I have to say we are tempted to see whether we can resolve a really good outcome for everyone involved through some more dialogue. Because I think, and I will say it, the other solution, the other outcome is that we've got a derelict industrial Victoria monstrosity that's sitting in a key part of the city that has all these very important cultural and recreational values and linkages that is beside port, which is the lifeblood of the Taranaki economy. I'm speaking plainly,
Yes.
quite purposefully on this.
Yes.
And we'll hear out the evidence because I'm really interested in Ross's evidence and certainly what Catherine comes back to. But I sense as a planning issue, there is a way forward, no matter how we might organise the process. So I just thought it's useful just pausing and putting that out there.
Well, look, I'm very grateful for that expression. And I say this, I very much respect what you've articulated in terms of what the consequences of going down this argument that I'm running in terms of scope might be in terms of the building remaining derelict and those other things. And I certainly respect that there may be a view that the panel is coming to about the merits or otherwise of the outcome. All I can really say in that space is whilst I completely understand the bind that I think this creates, in a sense, I can't give you a way out of that. And that is as straightforward as saying that the merits drive, because I totally concede that in the absence of the scope issue, that's where you're at. With the scope issue in front of you, I say you actually can't make the decision based on the merits. You do have to determine scope without that overlay. And this is the essence of the argument that I'm putting to you. And I appreciate the kind of binary position that creates, what I've said is an on-off switch, and the consequences that are, I think, understandably troubling to the panel potentially about what that would mean if you said there isn't scope, and where that then leads things to go in terms of the site.
Yeah. But just to be clear, we're still hearing the merits case.
I totally understand that. Yes.
And in terms of advice to us as decision makers, we've got some very senior counsel here that hugely value your input and advice on these matters, and we know that you're advocating for your clients, and that's the right. And through that advocating, we get the side of the story.
Yes.
That is the reason why we've asked for another opinion on scope. So I know your submissions were filed before receiving that. So,
well, and I do plan to give you some very brief responses. Yes. I'll include that as I go through.
But just to say again, the most troubling thing for me is the prospect of a very old, rundown, derelict part of New Plymouth that has such underlying values.
Yes.
For the city.
Yes.
And seems an opportunity to move forward from that, but there's a legal obstruction because your view, you're saying there's been some errors in the way the submission was geared that goes to our ability to implement relief now being sought. That's, I think, the first decision you have to make.
Yes, I think that's fair. And can I just reflect that there's possibly two different ways of expressing that. It's because I haven't said it so bluntly that there were errors made in the submission. You could look at it either that the disconnect arises because of the way the submission was written, or that the disconnect arises because of the outcome that's now sought. But the issue is you can't get from A to Z, which is effectively, you haven't got the rest of the alphabet in the middle. So what you've put in your terms as an error in the original submission, you could say it's an error to now promote all of this bespoke provision making, given the scope that we created with our original submission. We have to be more restricted in terms of what we actually ask for as an outcome.
One of the things I've, and correct me if I'm wrong, I think the Seaport submission talks about outcomes like Napier, Auckland, Wellington. That's something I've heard in evidence. I haven't gone back.
It says similar to those in other parts of New Zealand. It certainly says that. I don't recall it making us, but I'll stand corrected on that. But I don't recall off the top of my head making reference to other specific.
If someone could check on that, because if I'm visualising would a reasonable person who might show and poke around in the strict plan because it's in their own properties and interests, be thinking if those terms were used. We should perhaps find that out now. Mr. Nolan, do you know?
I don't recall it being specific.
No, that's just come through and perhaps,
Yeah.
we've heard, I'll be thinking of living in Napier and having lived in Wellington and frequent Auckland a lot. I'll be thinking, well, thinking about, something along the lines of Ahuriri in Napier, where boats bobbing along the lines, people sitting on decks in front of the restaurants type of thing.
Yes.
So look, just in terms of facts, there are no other submitters apart from the board, or further submitters on this matter. There are supporting some further submissions from the iwi parties.
That's right.
That's where we're at.
That is, yes. And I just on a quick review now, while you're talking, Mr. Chair, I think that is the only reference to paragraph 3 of the submission. There is that reference to similar to those in other parts of New Zealand.
Okay.
So
Let's carry on.
I was at paragraph 53, and I just advanced this proposition that there is a potential argument about an issue was raised and the outcome now before you is the solution to that issue. And I've said I don't think that that's enough to satisfy the reasonably and fairly raised standard. In support of this, I note that 2 experienced planners, Ms. Carter and Mr. Wesney, express in their evidence that prior to Seaport's evidence, they were unclear about what Seaport was seeking. In fact, they were so unclear that Mr. Wesney seems to have had to rely on a private briefing Seaport gave to council officers in order to understand what rules Seaport would be seeking. And Ms. Carter has relied on her understanding of Seaport's aspirations gained through Seaport's failed consenting process. If the outcomes now sought had been reasonably and fairly raised in the original submission, neither planner would have had to have recourse to extraneous processes in order to engage with the substance of what SLC is asking for. The second, and this is really only an implied retort, it certainly hasn't been expressly made by Seaport, is that there is this substantial consultation exercise that Seaport has undertaken and the development of its master plan. Seaport may say that its consultation and master planning can be relied on by the panel to demonstrate community support for its proposals and good fit with broader strategic considerations. When it comes to scope, such efforts are, in my submission, irrelevant. Scope is to be judged by what the submission as lodged reasonably and fairly raised. The fact that Seaport may have been able to garner support for its proposals by sharing more information with selected stakeholders long after submissions and further submissions had closed is further demonstrating the problem. If its proposals were reasonably and fairly raised by the original submission, one might have expected any significant support to have been apparent through the filing of further submissions. I acknowledge that Seaport is critical of the Council's consultation on the draft plan and critical of the strategic vision Council has for Seaport's site and its environs. Whether those criticisms are deserved or not is beside the point. Efforts by Seaport to make up for what it perceives as Council's shortfall, and I say that's effectively the exercise that Warren and Marnie was engaged to undertake here, cannot bolster the shortfall in detail in Seaport's own original submission. Put simply, if Seaport's consultation and master planning work had preceded notification of the plan instead of coming after, that would have enabled Seaport to provide in its submission far greater detail than it did. If not by including the 23 pages of detailed provisions it now seeks, then at least by including such detail as would reasonably and fairly disclose that potential outcome. It does Seaport's scope position no good whatsoever in my submission to rely on master planning and consultation that occurred after its original submission was formulated.
I express my take of the position that you had, I've called it error in the formulation of the submission.
Yes.
Is that different to the shortfall in detail, which you're saying is fatal?
I think they're different ways of expressing more or less the same thing. I'm hesitant to describe it as an error per se. It's simply that there is a lack of specificity, and that's an issue that I'll come on to, and how one thinks about lack of specificity, because that's how it's described in the submissions you've been given by Seaport. Yes, you can put it in a number of different ways, but yeah, shortfall is another way of saying the same thing. Now, at paragraphs 57 through 60 in the submissions, let me put it this way. I would like to withdraw paragraphs 57 through 60 of these written submissions and respect the evidence that you have received from Mr. Nagel on the consultation exercise that Seaport undertook. If I could take those as withdrawn, I'm not going to make any of those points with you. In summary, I submit Seaport's original submission actually took the right approach when it described its relief as back to the drawing board. Consistent with its criticism of Council's own consultation and its criticism of Council's ambition or vision for the site, it was presenting a back to the drawing board option that was only ever exercisable by the Council itself. And I said that at the time when I hadn't heard what you've told me, Mr. Chair, about some of the efforts you've made within the hearings process to encourage further work to be done on other topics. In response to Seaport's issues, Council could have withdrawn part of the plan to undertake the type of master planning exercise Seaport wanted. The same option is not available to the panel, and as Council chose not to take that step, the panel must determine whether Seaport's current proposal is within scope. And for the reasons I've already covered, I say it is not. That is, I can't leave the matter there because I do need to take you just to my responses on the submissions you've received from Seaport and from Council's lawyers. So if we can go to Seaport's submissions first. It might help in the spirit of reflecting how close we are in terms of agreeing matters if I say these are the submissions dated 17 August. I completely agree with the legal principles set out at paragraph 2.1, 2.2, 2.3, and 2.4. So that you won't hear any difference of opinion from me on any of those matters. Where we start to run into a difference of view is at paragraph 2.5. And this is where the first of three issues that I want to take you through arises. What's expressed there is that Port Taranaki is arguing that the submission suffers from lack of specificity, and it's put that it's said rather than an objection on scope. It goes on at paragraph 2.7, bottom line, bottom two lines, the absence of specific relief is not the same as a lack of scope. So my reading of these paragraphs, 2.5 and 2.7, is that Seaport is advancing a position that there is a difference between scope issues and lack of specificity, and I do dispute that. You have been taken by Seaport to one of the cases, and they referred to other cases in the footnoting. What I would say is I don't believe any of the cases, either the quoted or those referred to in the footnote, stand for a proposition that lack of specificity cannot be a scope issue. I say when you look at these cases, you will see that what in fact the courts have consistently done is turned their minds to the specificity in the relevant scenario in front of them and used that to determine whether there is or isn't an issue of scope. And that's a different thing from saying that there's a legal principle that draws a line between issues of one sort that are a lack of specificity issue and issues of another sort that are a scope issue. So if we go to the Motiti example at paragraph, set out under paragraph 2.6 of my friend's submissions. Thank you. The finding that is summarized and quoted at 2.7 is that in that case it was found that the original submission was, quote, sufficiently specific to alert members of the public to the potential outcomes sought. Now, I would say that is a finding of fact by the court in that case. And what is more, it's a finding that discloses that the court was directly assessing scope by examining the degree of specificity in the original submission. That's what I take from that language, sufficiently specific. The other two cases that are referenced in the footnote there, that's footnote 11, are Shaw and Telecom New Zealand. And I'll just take you perhaps to the Shaw case because they're both in the casebook I've provided you, and I'm really hesitant to spend much time going to the cases, but I think this is helpful if we go to Shaw paragraphs, so it's behind tab 4. And the passage that my friends have referred you to are 32 and 33 of Shaw. And I'll just take you through those. The court here is Justice Chisholm saying, I note that a somewhat similar issue arose in Telecom, where a relatively broad brush approach had been adopted in the submission and reference in relation to objectives and policies. Despite this lack of specificity, the Environment Court concluded that no one had been disadvantaged and that it had jurisdiction to hear the appeal on its merits. In contrast to that approach, it seems to me that on this occasion, the Environment Court adopted an unduly narrow approach when it reached its conclusion that no new objectives had been suggested by either referrer. And then the first sentence of 33, at the hearing, the referrers were entitled to provide more detail about the proposed objective and policies, but that did not entitle them to go beyond the scope of the packages signalled in their submissions and references. What the High Court, I say, is describing in the passage I've taken you to is how the principles have been applied in the Telecom case. And it's not describing there the development of a legal principle that specificity and scope are two different things. It's simply describing the factual determinations that were made by the court looking at scope through a lens of specificity. And I say this is consistent with all of the cases that I or my friends could take you to. So I disagree with the proposition that my friends are advancing, that there are two different things, specificity and scope. I think it's a question of degree. The next point that my friends make is at 3.12. It's the next point I want to at least respond to, and there are three things I'm responding to here. And that is the last line of 3.12. They say the development of specific objectives, policies and rules through the hearing process in reliance on the original board submission is consistent with established authority. I want to be very clear that I agree the cases support some amount of development of detail. And I agree also with a proposition that was advanced, I think, orally, that, and perhaps in writing too, that it would be completely unworkable if submitters had to have every detail that they ultimately are seeking sorted out at the time they draft their original submissions. That's not the proposition I'm putting to you. I don't think that that's the requirement in order to get scope. You don't have to have every T crossed and every I dotted at the time you file your original submission.
So that's certainly the best we've applied. We've asked further work to be done on the specificity of, for example, the development area.
Yes.
And we've satisfied in each of those cases, a number that we've got further work done. And we'll go back to us through the 42A rights replies after a process.
Yes.
Yes, right.
Well, I think that the point that I differ on from my friends here is it's not without limit, this proposition that is the last sentence of their paragraph 3.12, this allowance for development of specifics at a later stage is not open-ended. It requires you to strike a balance to ensure that the changes that you ultimately presented at the hearing can fairly be said to be a foreseeable consequence of the changes that have been directly proposed in the submission. And I'm drawing there deliberately on the language that you'll find back on page 2 of my friend's submissions, and that's taken from the orthodoxy in Albany North landowners. It is sufficient if the changes made can fairly be said to be foreseeable consequences of any changes directly proposed in the reference. And part of the problem you have here is that there's a lack of changes directly proposed in the original submission. It raises an issue, but it doesn't go so far as to say what the relief sought, what the solution would be.
Do you think we could look at the detail that's now been presented and look at the surrounding parties? For me, are the railway line owners, the road authority, the residences across the road, and I think that in trying to look at the scope of what we have in the submission, now the detail, whether can we put ourselves in the shoes as decision makers of those other parties as part of our deliberations, because we do have a discretion to make a finding on scope.
Yes, you
It's our
do.
job.
It is.
And this is quite complicated because during the submission period, as I understand it, the resource consent had been lodged
Yes.
and notified.
I believe it was notified shortly before the plan was notified.
I think it was notified the day after submissions on the PDP closed, but there had been, I think, Mr. Snowfield referred to the dates for the submissions, but there had been substantial media coverage.
Yes. So with the substantial media coverage, it was around any of those parties that were alive to the news of the day would be aware that something along these lines, as set out in the resource consent applications, was afoot. And can we take any instruction from the submitters that actually lodge submissions on the resource consent application?
Well, can I say two things about that strike me straight away? I think most of the people in this room understand the difference between a planning process and a resource consent. But if the proposition is that the genuinely interested, reasonably informed member of the public has that same degree of understanding and would have understood that the planning process was ultimately trying to get to the same outcome as the consenting process was, I'm not sure that that's a conclusion that one can assume on their behalf. I dare say for even an interested member of the public, it could be confusing to most people as to, well, if you get your resource consent, don't you get what you need? Why therefore is there a planning process running alongside that? What's the goal of that? And I'm not meaning to make any more of that. I'm just meaning to tease out that I think that in terms of relying on the media coverage of the consent process that was underway, I think you need to be a little cautious there about inferring what level of understanding that might have given to would-be submitters on the planning process.
Okay. I'll tease this out a bit more. There had been presumably a big for sale sign up on those cool stores for a couple of years. Yeah, so that's just another fact that would alert people to know that something could change there if you're interested in your neighbourhood.
And look, I don't dispute any of that. And I also, maybe I can take that usefully a step further and say, I certainly don't dispute that Seaport's submission is very clear that it didn't want what the plan had given it. as notified. I don't think there can be any, it couldn't be any clearer about that. So there's no question in my mind that that genuinely interested, reasonable, hypothetical person in the public looking at the Seaport submission should have understood if Seaport gets what it's asking for, whatever it is, it won't be what the plan as notified is. Now, I think the way that is framed or was framed by my friend is that if you're just thinking about scope, forget the merits, that means the whole landscape was available. Any outcome could have been available because the Seaport submission was simply any outcome other than retaining the plan as notified was available. And I have a real problem with that because in my mind, it's really reducing the value of submissions as the document that informs other parties with a potential interest. It's reducing that value down to saying, well, it's enough for a submitter to say, I don't want what you've given me, and leave it there. Now, I'm not suggesting that it's quite as basic as that in terms of Seaport submission, but I do think that's the kind of argument that in a sense you're being offered there in terms of that scope. The other thing I want to say though, in terms of the question you're asking, Mr. Chair, about whose shoes you might put yourselves in mentally, hypothetically speaking, is with all due respect to the evidence you've had from Mr. James and now Mr. Heath and the direction of travel that those issues seem to have gone, you don't have in front of you any submissions from commercial property owners in the centre or the owners of small businesses within the centre, or for that matter, property owners, commercial landlords or business owners within the Moturoa mixed use zone and town centre zone that's just up the road from the Seaport site. And I do have some difficulty with the notion that that you're loaded up with this expectation that to get around the scope problem, you undertake a mental exercise of putting yourself in the shoes of all these hypothetical parties everywhere who might have wanted to have some say. The reason we have the scope limit is to prevent you from having to do that very exercise.
Yeah, but doesn't Justice Fotter at his 176 in Albany?
Yes.
His word, we need to, our approach should be a test based on what might be expected of a reasonable person in the community of large,
Yes.
genuinely interested in the implications of the proposed future plan in this case for him or her.
Yes.
But isn't that our test?
It is what he says, but he's not saying that cuts across it's not a way of solving the scope problem. It's simply that you need to be asking yourselves, in terms of that question, was it, quote, reasonably and fairly raised? You put yourself in the shoes of that party. And you say, what would that party have understood this to mean? Looking at the original submission.
Would agencies like Whakatane, New Zealand Rail, and Ministry of Education on behalf of Motorola School be one of these reasonable persons in the community at large, or would they be treated like the iwi to perhaps take a different, or have professionals looking at things, and because this is where I'm sort of thinking that we do have key parties that could potentially be affected either by the proposition as advanced in the scope of the submission, which you're saying is unclear, or by the detail that has now come through that we've been asked to facilitate through our decision making.
I'm really hesitant to I don't think it's really for me to express a view about what the ministry or what Kotahi or those agencies might have done. What I would say is it does seem to me that the issue that you're thinking through, and I accept very much that this is that these are live issues in your mind, are somewhat they're somewhat more akin to identifying who might be appropriate for limited notice on a consent process than the public participation policy that applies and that Justice Whaka is very clear about applying in the planning process, where the idea is the door is thrown open at the start and everyone who has an interest gets their opportunity to have their say. And the issue we have now is, have those parties had their opportunity to have their say, given the disjunct between the original submission and the outcome that is now sought?
Okay, I think we'll just move along.
Yep.
Obviously,
No,
it's very live.
Happy to keep going. The last issue is at 3.10 of my friend's submissions, and it's the last line. It is the meat on the bones of that broad relief falls squarely within the range of options between the notified plan and the submission. And what I understand the submission that's being advanced to you is that the outcome that is now in front of you occupies what is described as the middle ground between the plan as notified and the outcome as sought in the original submission. Now, the legal principle is totally agreed between us. We're all in agreement that the way this works is you have the notified plan and the original submission, and that sets up not just you have one or the other, but it also sets up all of the options that are in between those two extremes are potential outcomes of the process. That's your range. But where I differ from my friends for Seaport is that I say the outcome that's now on the table does not actually stick within that range. So the way they have put it, they've said the submission asked for mixed use zoning. They've emphasized how many times the phrase mixed use appears in the document. And if I take that at face value, the problem becomes that there are many aspects of the provisions now in front of you that are less constraining than the mixed use zoning is, that are more permissive than the mixed use zoning is. And examples there are, it's more permissive in respect of residential activity. It's more permissive in respect of visitor accommodation, retail activity, business activity. These are all examples where, rather than taking the mixed use zone as it exists within the district plan framework and saying that's what we're going for here, and then we'll have some additional controls on that are more limiting of what might eventuate, we actually have an opening up of the mixed use zoning, a transformation from what exists elsewhere as mixed use zoning within the plan into something that is more permissive. So I say there again, that is an issue for Seaport in terms of the range that is permissible. And it falls foul of the scope problem. Now, those are the points that I wanted to make in response to Seaport's submissions. I think I can be much more brief, having addressed all of that. Can I go quickly to the submissions you had from Mr. Wakefield and Ms. Viskovich, and just go to the page before the concluding comments. There's a page number that's got paragraph 17 at the top. And I'll just focus on what I think the main points here are. Firstly, at paragraph 19, they have noted that the port took the opportunity to make a further submission, and the same point is made in Seaport's submissions. I simply want to place on record that whether the port made a submission, a further submission or not, isn't actually relevant to the scope evaluation. the question becomes, were other parties sufficiently on notice of what the outcomes might be? And it should be clear from the nature of the port's further submission that what the port was doing was resisting what Seaport was asking for at the same level of generality that existed in the original submission. So I don't think it gets you any distance into solving the scope problem to say, well, the port was able to identify that there was a matter here that it needed to file a further submission on.
Is this argument linked in with the comments you made yesterday about the port not necessarily advancing its own interests, but the wider interests of the community? Or is that more about the wider interests of the community in terms of looking after regionally strategic infrastructure, whatever the term of art is, it's currently in vogue?
Yes, I hadn't put those two concepts together
Together,
particularly.
yes. But are you saying that the port is concerned that other neighbours of it haven't had the appropriate opportunity to participate?
And not just neighbours, but business owners in the centre, business owners in Moturoa, commercial landlords in those locations. So the second point is at paragraph 20. I just want to observe for your benefit, as I understand the submission that you're being given by the council's lawyers, they are placing a lot of reliance on the consequential relief framing in Seaport's submission. They seem here to be saying that everything that's in front of you can be brought in as consequential. And I guess the simplest way to express the disagreement is to say, my view is consequential relief has to be a consequence of something. And that's really what we're missing here. We're missing the something. We had the original submission identify the issue. I don't dispute that consequential relief is always there to do some of that heavy lifting to provide a bit of flexibility and allow the process to evolve within the Schedule 1 framework. But it's not there to replace the guts of what should have been in the submission in the first place. And then the last point I'll make on their submission is simply at 21. There's a bit of a straw man argument here, I think. They've referred to my submissions where I had said that there isn't a single provision in the submission to address the issues. And they put it, if in every case the relief sought had to be set out specifically before there could be scope, then, and so on. And that really is not what I'm saying. I hope I've made that very clear. I am not saying that you needed to have the 23 pages of detailed provisions in front of you, or needed to be included in the original submission. What I am drawing to your attention is that you're not dealing with one of these finely balanced cases that are so frequently the subject of court decisions, where a party might have said, I want this objective changed. And then there might be an issue about whether a related policy and rule are within scope. Or a party, conversely, goes up the other way as well. In terms of the hierarchy, a party comes before the court saying, it files a submission saying, I want the rule changed. But doesn't talk about the objectives and policies. And it's well established. And maybe I can just take you to this too, just to make sure that this is all very clear. This is covered in the submissions at tab 7 of the reference materials for Commissioner McMahon's benefit. These are the submissions, because he doesn't have the tab list. These are the submissions on Blue Haven, dated 26th of June. And I just wanted to say, I mostly agree with the principles that are set out here, but there's a principle at 2.16 that has been expressed, I think, in a way that is probably very useful for you to have in mind here. Consequential changes can flow downwards, as a submission might only be on an objectable policy, but there may be methods which are then incompatible with the new objectable policy in the proposed change as revised, and consequential changes may also flow upwards as a result of accepting a submission point, e.g. changes to the policies may be required as a result of amending a method. So it's well established in the case law, there's no difference of view from me with that statement, that if you've got a route in, if you've got a rule, you've got an objective, you've got something that has been the target of the submission, you have some room to move within so that the end result is vertically integrated between the objective, the policy, and the method. But we just don't have that step in.
Can I ask you, if you read the submission from Seaport in the round, whether an objective of what they're seeking can be made from, because an objective, as we think about it, is an objective crafted in a plan.
Yes.
An objective, when you look at the normal usage of the word objective, is, what would we like, what are we wanting to achieve on our land?
Yes, I don't think I have any dispute with that. I think that the issue is in the how precise the objective is, and I've endeavoured to be fair to that in terms of the quotes that I've pulled out of the submission, put into mine, because it does talk about a vibrant mixed use development. There's no question in my mind that there were signals in the original submission about the outcome at that level. I think the problem really arises, as I see it, between that level of generality, that common understanding of the common meaning of objective rather than the planning meaning, and the level of detail that's now in front of you.
Okay.
So
thanks for that.
I'm happy to keep going on.
Keep tagging along.
That is all I'm going to say on the scope issue. It's okay to hear me say I'm at paragraph 62 of the legal subs. Retaining the port zone is the most appropriate outcome. In the event that the panel decides that there is scope to consider Seaport's proposed zoning provisions, an assessment must then be made under section 32, and I should say, of course, also section 75. I haven't expressed it in those terms, but I think that's an understood fact. Whether the new objectives proposed by SLC are the most appropriate way to achieve the purpose of the Act, and whether the provisions proposed by SLC are the most appropriate for achieving those objectives and the other existing objectives of the plan. So that's the section 30 summary of section 32 framework. The first of these assessments must, of course, be guided by the relevant content of the higher order planning instruments, which, subject to the usual limitations, can be taken to be an expression of how the purpose of the Act is to be achieved. This is where a key difference of opinion arises between the planners. On the one hand, Ms. Carter and Mr. Wesney are both of the view that the Seaport proposal will not uphold key coastal policy statement and regional policy statement policies, which reflect the port's functional need to locate in the coastal marine area and the need to ensure the efficient operation of the port is not adversely affected by development in the coastal marine area. Ms. Hooper seems to agree these policies aren't relevant, but concludes Seaport's proposal will be consistent with these policies. Materially, the same positions are taken between the planners when it comes to assessing Seaport's proposal against the PTP's strategic direction objectives, Ms. Carter and Mr. Wesney both concluding that Seaport's proposals are not in keeping with the objectives, and Ms. Hooper reaching the opposite conclusion. In my submission, the positions adopted by Ms. Carter and Mr. Wesney more appropriately reflect the basic incompatibility that can arise between a port and sensitive, i.e. residential activities, as given expression at the national, regional and district level. I note also that if port zoning is retained for the site, there will still be requirements for future use to recognise and preserve the significant cultural and historical values of the site under provisions for historic heritage and sites of significance to Māori. And in this respect, Seaport's proposal cannot be considered any more appropriate than retention of the port zone. For completeness, I record that Port Taranaki also considers, based on Mr. Wesney's analysis, that Seaport's proposal is inconsistent with the hierarchy of centres sought to be maintained by the strategic direction objectives. And of course, we get to hear that Mr. Wesney still holds that view in light of what we heard yesterday. I also submit Ms. Carter's and Mr. Wesney's approach correctly avoids an anomalous spot zone of mixed-use land inside the port zone. And I won't go through that in any greater detail because I think there is a question at large at the moment about how the rail line behind should be treated. But I would say this, that whether it's a spot or some other form of it, well, it's still a spot. It's just not necessarily an island surrounded on every side by port zone. If the Kiwi Rail line that runs down the rear side of the site takes its zoning halfway to the centre line from whatever the zoning ends up being on the seaport side. At 70, the master plan developed by Warren and Marnie depicting a vision for the wider area must be disregarded for the purposes of this assessment. None of the aspirations reflected in that work can be delivered by the present process, which is limited to Seaport's site. This reinforces that the only suitable way to properly address Seaport's aspirations within a context of wider potential change was either, one, for Seaport to have lodged a far broader submission encompassing the wider area and the types of change envisaged by its master planning exercise, and for that purpose the master planning would have had to have been undertaken prior to the submission. Or two, for Seaport to convince the council to withdraw the relevant parts of the plan and undertake a broader planning review for the whole area, which in my view is exactly what Seaport was expressing as a back to the drawing board option. I say none of that assists Seaport here, where your jurisdiction lies, as I've discussed already, in this range between, at the one end, retention of the existing provisions as notified, and at the other, by the matters fairly and reasonably raised by Seaport's original submission. Now, it might help here if I also signal, I just inject here that there are matters that I am in complete agreement with Seaport on in its primary legal submissions. These are at the setting up of the legal framework, which is section 4 of the legal submissions. And they've set up there a summary at 4.1 through to 4.7 that is totally agreed in terms of what the legal framework for your assessment is. And the important point at the end of that section is the point I was making yesterday about there being no presumption in favour of the status quo, which I've been very clear is an agreed point. I want to say two things about that, which is while that principle, that legal principle is agreed, it is inescapable that the existing environment here includes the port. You don't approach the analysis here as if everything's a green field. So we have the port, and the port will continue to be here. In addition to the port's actual presence, you have a hierarchy of higher order planning provisions that strongly support the making provision for the port so that its operations are efficient into the future and protected from incompatible development. So whilst there is no presumption in favour of the status quo in a strict planning sense, I think that you have to be realistic when you come to look at this site and its relationship and proximity to the port and say, well, the port is there and we have a set of higher order provisions that tell us not only is the port going to be there into the future, we need to be providing for its ongoing operation. And that is relevant context in my submission for the merits assessment that you're undertaking.
So what do you say, and this is back to the wrestling we're doing, about the zoning, because the port zone is on this land, that's the status quo.
Yes.
And we have a derelict old industrial building that you could describe as a blot on the landscape.
Yes.
Under a port zoning, its only ability to move forward as an area of land or the site is for it to be developed under port zone
Yes.
anticipated activities.
Agreed. Yes.
Yes, the port has, and I've asked Ross to confirm this, has made a specific decision not to acquire the site itself. And that's a question of fact I'll need to establish. And at the same time has acquired other land to the west of the current port for development and expansion. So the dilemma we have is we've got this large piece of derelict infrastructure, the status quo of port zoning. The port doesn't seem to want it for port activities. And the city, if we just go down this path and make a decision that we don't have proper scope and just have to leave things as they are, has 10 to 15 years more of this problem.
I agree with you, it's a dilemma. And I'm a little bit cautious about agreeing with the proposition that it creates a sort of a 10 to 15 year ongoing problem. And the reason I'm reluctant to disagree that proposition, I totally accept that's the time frame for this plan, roughly speaking. But I think behind that is a premise that if you were to confirm the port zoning as a result of this process, that on the basis of the very clear convictions have been expressed by Seaport that it will not use the land for port purposes, that you would expect it to be a derelict building for the next 15 years. And I don't agree that as a proposition. And I think you can probably direct some questions to Mr. Dingle about what his expectations might be around that. The reality, of course, here is no one's in any doubt about the outcome Seaport would like to get from this. Seaport's convictions are expressed in the here and now at a time when it still has that outcome potentially in front of it, i.e. that it gets the zoning changed, it gets the ICB changed and so on. Seaport is not giving you a view that says, well, what if we don't? What would we then do if we're left with the port zone, with the ICB where it is? I think that they're inviting you to conclude that come hell or high water, they're not going to be using the building for port purposes. I think that's
a commercial decision.
It is.
It's outside our control. All we've got control on is a future zoning pattern.
Yes.
For this plan.
Yes. Yeah, and I think that's a very fair way of putting it. And I guess what I think it comes back to, this dilemma that you're grappling with, is probably right at the front end, the test that I set out at 62.1, whether the new objectives proposed by SLC are the most appropriate way to achieve the purpose of the Act. I do think you have quite a front and centre, you have a decision to make about in the sort of broadest possible RMA sense about what's the right objective to point this land towards in terms of the RMA's sustainable management purpose.
Yes.
Yep.
Okay.
So I was at the reverse, paragraph 72. So for all the reasons I've covered, I submit the outcome sought by Seaport cannot be considered the most appropriate for the site. I submit that the views taken by each planner in assessing whether the proposal is most appropriate in relation to noise matters is closely linked to their respective views about the likelihood of reverse sensitivity effects actually arising from Seaport's proposal. And that's the matter I'll turn to next. You will hear from, or you have heard from the noise and some of the planning experts, divergent views as to the likelihood of reverse sensitivity effects arising and the ability of those to be appropriately managed. To add to what you hear in the evidence, I make 4 points from a legal perspective. Firstly, the courts have long since accepted that the role of decision makers in these settings is sometimes to protect people from an adverse effect they have knowingly subjected themselves to, i.e. protect them from their own folly. Secondly, the fundamental incompatibility between ports and residential neighbours is self-evident and has in any event been the subject of a number of environmental decisions and is represented in the provisions of the New Zealand standard itself. And what I mean by that is there's a large part of the standard that just wouldn't need to even exist if we weren't trying to set up some method for managing this incompatibility. Port Taranaki is no different than many ports in this respect. It is a 24/7 operation that inherently gives rise to noise and other effects that cannot be internalized. And can I add at that point that Mr. Fitzgerald's evidence, and Mr. Fitzgerald has said in his evidence, all of the ports, and it is a great number that he works with, his evidence is that Port Taranaki is unusual amongst those ports for how dynamic the changing environment is. Thirdly, the port is not limited to its present activity. As Mr. Dingle's evidence demonstrates, the port is a dynamic environment liable to change, particularly over the lifespan of district plan provisions. Such changes may include operational port activities occurring closer to Seaport's site and flanking Seaport from both the west and the east. And this includes allowances in the plan for such activities to emit far more noise than is presently experienced on the SLC site. Related to this, I note that the New Zealand Standard records that planning is required to preserve appropriate, quote, development potential at ports. And the setting of noise control boundaries is intended to include areas where there is reasonable potential for growth, viewed over a minimum 10-year time span. Further, the standard states the setting of boundaries will require assumptions about the scale of port utilisation. I say this does not require the port to prove what the future will hold. Rather, it requires you to adopt a suitably long-term and growth-oriented vision for the port's future to ensure a reasonable allowance for development potential has been made. And in case it's not clear from that, I really am inviting you to not share what I would describe as Mr. James's pessimism about the port's future. And I'm saying to you that that's also not what the New Zealand Standard is telling you to do when you think about port utilisation and what kinds of noises might result from that.
Yeah, and I think we'll hear from what's about the other side of the story, and that will be interesting.
So I'm at paragraph 79 now. While it has become common for residential developers to offer no complaints covenants to existing industrial neighbours, it is imprudent to place much faith in the effectiveness of such covenants. And there are a number of reasons for this. I've given just 3 here. Firstly, the signing of the covenant itself does nothing to mediate the signatory's experience of the actual noise. They will still experience the same noise in the same way as if they had not signed the covenant. And if they find the noise unreasonable, then the prior compulsion to sign a covenant so as to be allowed to purchase an apartment on the port's doorstep will do nothing to lessen that effect. And I don't know that I need to unpack that too much. I'm really just saying there it's plain that in order to get to the outcome Seaport is offering in the terms of no complaints covenants, and it's conceded that they say they don't need them anyway, that would be achieved by ensuring that purchasers of apartments in their future development would have to sign one of those as part of the purchase agreement. Second point, a potential apartment purchaser may judge the noise of the port on the day they visit the open home, but the noise on that particular day may not be representative of the noise that is frequently emitted or the noise emitted at night. Given the port presently operates below allowable noise levels, a purchaser is unlikely to comprehend just how noisy the port is allowed to be. Third point, it is notoriously difficult to enforce such covenants as reverse sensitivity can manifest in very indirect ways. And I do want to take a moment to just unpack that a little bit for you, because I don't disagree with the definition of reverse sensitivity that my friends put into their submissions. I want to draw attention to the fact that it's inherent in these kinds of cases where reverse sensitivity is argued to be an effect, that you're dealing with what I would describe as a double layer in terms of assessing the probability of the outcome. In an ordinary RMA assessment, you're dealing with a single layer of probability, which is, will the primary effect arise? Will the noise effect on the resident occur? Here, you have to be thinking about, will the noise effect on the resident occur? And then there's this second layer of, will that result in a reverse sensitivity towards the port by the resident or residents? Now, the reason I'm emphasizing that is because it is inherently difficult in reverse sensitivity scenarios where you are layering up both of those probabilities to view that kind of outcome on a sort of an even playing field with looking at the more concrete and tangible offering that Seaport has got in front of you in terms of its concepts for the site. And I really just wanted to highlight that I see that disparity, and I urge you not to be led down a path of thinking that somehow the fact that you have to make this multi-layered assessment of probabilities in order to make a reverse sensitivity, be convinced that there is a reverse sensitivity issue, doesn't actually lessen the strength or importance of that issue. I should say here, that relevant to that, that one of the criticisms that I think is made of the port's case on this reverse sensitivity point is that the port hasn't quantified how big of a problem this is. And the 2 points I would make about that are, the port is in a somewhat difficult position here in that there isn't a concrete proposal in front of you as to how many residential apartments might the Seaport development contain. I think you can probably get to some idea around that by looking at the consent application, which was something in the order of 90 units, as I understand it. Some of those were the commercial units, some were the residential units. But I think that the point to be made here is the number is, whether it's 70, 75, 80 or above, it's something of that order or bigger. and that is a very significant change for the port in comparison to the number of residents that presently reside inside the OCB, in that band between the OCB and the ICB. And it's a change that occurs in one hit. Now I'm accepting Seaport will be developed over some time if it goes ahead. Unlike infill residential development that might occur throughout existing residentially zoned sites, this proposal is one big chunk of residents all delivered to the port's doorstep in one hit. And that's a point of difference in my submission. Thank you. I'm at 80. When you assess the evidence in light of these points, I submit you may find there is a stronger foundation to be concerned about reverse sensitivity effects on the port, as Ms. Carter, Mr. Wesney, Mr. Fitzgerald, and Mr. Lloyd are, than to not be concerned, as Ms. Hooper and Mr. Stiles are. And can I just, for the record, note there that Ms. Simpson's evidence yesterday I thought was very fair in terms of her views on air quality matters. And I think in particular, she acknowledged that there is an issue that comes from the density of the proposal that Seaport is putting forward. Now, her view, of course, was that is adequately addressed through the ability to close doors and windows, the design of the layout, and also the imposition of no complaints covenants. But I think what she was picking up on in terms of that density is the same point that I'm making, that we're not dealing here with Mr. and Mrs. Jones infilling their back section, and then Mr. and Mrs. Smith further up the road, also inside the OCB, infilling their back section, and you have a couple more residents and growth over time. We're dealing with a rate of change that doesn't resemble that if Seaport gets the provisions that it's asking for. Now, how you determine these matters, I say, will likely influence the conclusions you reach, whether Seaport's proposal will better achieve the purposes of the Act and other plan provisions than will retaining the existing port zones. I am going to read the conclusion to you, and I don't mean to take up any more of your time than I need to, but there is one more thing that I need to do before I go to the conclusion, and that is to address a couple of matters that were covered in Mr. Fitzgerald's evidence, and just to make abundantly clear, and this goes back to a point I made yesterday that I said I would come back to, abundantly clear what the court's position is based on Mr. Fitzgerald's evidence. So the main focus here is on this inclusion of the reach stacker and the container lift on the SLC site. And Mr. Fitzgerald has been very plain. He included those in his 2035 modelling, and he did that on the assumption that that land would continue to be port zone. So there was a premise there. I say that's actually become a distraction that it does not need to be for the purposes of this hearing. It's a red herring. It's a red herring because the port is not in fact relying on the potential presence of those kinds of activities to justify its position. The reason for that is Mr. Fitzgerald has been very clear in his evidence that even without those elements, the noise levels will be 55 to 58 dB on the site. I think there's an agreement between him and Mr. Lloyd and Mr. Stiles on that. And his view is that that renders the site inappropriate for enabling large-scale noise-sensitive activities, such as Seaport is proposing.
At 55 to 58
Yes.
dB.
Yes. And I think it's really important that you understand a distinction that Mr. Fitzgerald has covered in his evidence and was restated within the summary statement that he provided to you and he presented briefly. And it's this: we know that the port noise standard says in the band between the ICB and the OCB, which is theoretically between the 55 and 65, in that band, residential activities should be permitted. That's from table 1 of the standard. And so it seems controversial that Mr. Fitzgerald's view is it's not appropriate to have residential activity here, because it seems to be going against what the standard is saying. Mr. Fitzgerald has endeavoured to explain his reading of the standard, and it is effectively this, and I'll give you the paragraph numbers and I won't take you to them because I don't think we need to dwell on it. His evidence in chief at paragraph 7.17, and in the summary statement that he provided to you, paragraph 3.9b and paragraph 3.10. And I think when you look at those and read them closely, you'll see that what he does is he draws a distinction between residential development of sites that are already zoned for residential purposes and that by their nature involve ad hoc site by site infill style development. He says that is okay, subject to insulation, of course. What he says is not okay is a wholesale rezoning of a large area to enable a large scale new residential development. And his view is that is consistent with table 1 of the New Zealand Standard. I won't endeavour to explain that anymore because that's what I say his evidence does, and I simply invite you to reread those paragraphs very closely so that you understand that. Effectively, what this all comes down to is a question of scale. The larger the increase in the receiving population of sensitive residents, the greater the likelihood of reverse sensitivity effects arising, and the greater the potential impact on the port from those effects. I think that brings me to the conclusion at 82. In summary, my key submissions are these. 1, the zoning for the site should be decided before the location of the ICB is decided. 2, there is no scope for the zoning outcome that SLC now seeks, as the 23 pages of bespoke and detailed provisions now sought were simply not fairly and reasonably raised by the original submission. 3, if you consider there is scope, then the zoning outcome fails the requisite merit-based section 32, and I mean section 32 and 75, of course, assessments. And on the basis of Ms. Carter and Mr. Fitzgerald, there should be only one Mr. there, apologies, evidence, retaining the port zoning is the more appropriate outcome. 4, the port is justifiably concerned about reverse sensitivity effects, which are real and substantial and ought to be avoided. 5, on the basis of the submissions at 1 through 3, the ICB is correctly drawn so as to encompass the seaport site. Now, I'm happy to answer any more questions you might have for me.
Yes, I do have one more question. It's about your red herring point.
Yeah.
So we received evidence from Mr. Fitzgerald and read the colour.
Yes.
With 2 red blobs of noise in the middle of and adjacent to the seaport land.
Yes.
So that was his evidence.
It was.
And he gave that evidence because of the requirement and the standard to look at a reasonable future. And he accepted prodding, I'll have to, admit that it wasn't a reasonable future to show port activities of that nature and scale in that location when you're looking out 10 years. So are you saying we should just, and you're saying, okay, well, let's accept it, but his real point was new residential's not really okay in a block in an area of 55 to 58 dBA noise reception?
2 points. Firstly, I don't disagree with your description of Mr. Fitzgerald's evidence and what he said in response to your prodding, Mr. Chair. I do say, though, that Mr. Fitzgerald was very clear that, and this is consistent with the legal submission I've advanced, that the zoning decision is made first, and then you decide where the ICB should go. And Mr. Fitzgerald's approach, therefore, in including those red blobs, was based on the premise that the zoning would be port. I totally concede, he, as did he, that if it's not zoned port, then you're looking at a different scenario. You're not looking at the noise contour map that he's included in his modelling, because it wouldn't have a reach, stacker, and a container lift on it.
But the discussion we had was looking at a reasonable future. Term reasonable, as you outlined 3 times in your paragraph 78,
Yes.
is the test. And given the fact that it is not owned by the port or a port-related company,
Yes.
was it reasonable advance to us, the decision makers, that receiving noise, even though he's said, well, it's port zone, therefore I have to do this.
Yes.
I was asked him in the round, given what he knows and we know of the evidence.
Look, I completely understand the point you're making. And can I say this? You're uniquely placed in this room, you and Commissioner McMahon. You're deciding the zoning, not Seaport, not the port, not Mr. Fitzgerald. So when he says to you, my premise is that it's zoned port, in the background to all that is, it's not for him to say whether it's going to be port zoned or not port zoned. And he says very openly, very clearly, that's a planner's job, not his job as a noise modeler. So when you put to him the proposition, what if it's not zoned port? You're inviting him to speculate about the outcome of the very deliberation that you're undertaking. Now, there's nothing wrong with inviting his view on that, but I think what came out of that whole exchange is he hadn't gone down that route because he was blind to it. He had not gone down that route because that's the nature of the very decision that is being made as part of this district planning hearing.
Is it something that planners looking at zoning should be turning their mind to in terms of the reasonable future?
Yes, I think it is, and can I say, I think you end up, I think this is where probably you sort of get to the circularity issue here, where it seems somewhat easy to say, well, let's do some noise modelling, let's add in land that the port that is port zoned. Therefore, we need to know the zoning first, and then the noise standard is telling you also have to think about all these other things to assess whether you've landed in the right place or not. And those are more planning oriented than noise modelling. And I think all of the circularity that exists, whether you put zoning first, ICB first, however you in the end decide to approach that, I think the way through all of that and the way to circuit break the circularity is to actually come at it from the effects standpoint. will there or won't there be an effect, and what will that effect be? And so I say that's why I have submitted at paragraph 81 that how you determine the reverse sensitivity argument that the court is putting up will be the driver, I think, in terms of all of those things. Because it's almost that you need to make a decision, it seems to me, about that argument, what the reverse sensitivity effect will be, and everything else will hang off that. Because then you can make a sensible zoning decision, and you can make a sensible decision about where to place the ICB and the OCB. You can't really make those decisions without that.
With the
Yeah.
evidence.
Yeah. The second point that I wanted to just return to in relation to the questions you were putting me about Mr. Fitzgerald is you had understood exactly, I think, what the proposition I was advancing is if you remove that 2035 map and ignore the red blobs, his evidence is in the 55 to 58, which is an agreed assessment, it's not appropriate to have the activity. So you can take the blobs off, and that's why they're a red herring.
Yes. Thank you for that.
Okay, thank you.
And look, I won't apologise for the discussion because all that, you know, because the issues and choices we have are very well formed in our minds. You happen to be the one that we're sort of testing these with, and as with the other council and experts, we're going to really take on board your thoughts. So look, I think, David, you've probably got questions. I won't. Yes. Let's take a break and come back at 11:10. Thank you. Welcome back, everyone, and Slyfield has just made the coffee run just in time, so the teams what they need. David, I understand there's one question. So David, over to you.
Yep, thanks, Stephen. I'll try and make this as succinct as possible. Mr. Slyfield, just checking that you can hear me okay.
Yes.
Okay. My question relates to the timing of the assessment that's in front of us in the sequence, whether we make a call on the position of the ICB first or whether we make a call on the zoning. And I understand your position is that we should and must make a decision on the zoning first. Is that correct?
Was that the, I'm sorry, I hadn't appreciated that was the end of the question, but yes, that is, if I heard you correctly, it is my submission that the zoning should be decided ahead of the ICB.
Yes, that was probably just a context to the question that follows, Mr. Slyfield. So, but based on that answer, is that a mandatory position? Is there any discretion for the panel in changing the order? Is that, and giving that answer, presumably you're relying on the Portnoy standard to reach that position?
That's correct. I am totally relying on the Portnoy standard to reach that position, and given the concession that it is not any more than guidance, albeit I think very strong guidance, if I can put it that way. I do think there is a discretion available to you to approach matters in a different order. I think I've made clear what I think one of the challenges in reversing the order might be, that you are left unable to give effect to the direction in the noise standard about including land shown for all purposes as being within the ICB.
Thank you. Thank you. Just so that I haven't misunderstood anything, because the sound quality isn't quite as I was hoped. Did you say there is discretion to reverse the order in the standard, or
Yes,
that
I do.
there is not? There is in the affirmative.
There is, I think there is you do have a discretion to approach those questions in the opposite order than I have suggested.
Yes, and that's because the standard is a guide only. Is that correct?
Well, yes, it's partly because of that, and it's partly because if you go to the standard, as I've signalled, there is in fact a sort of a circularity there anyway, that at the tail end of it, and I'm referring here to, it's fine, make sure it's 6.4.7. The guidance provided at 6.4.7 is the local authority should consider whether proposed inner control and outer control boundaries would be a reasonable basis for future land use planning, taking into account, and then there's a list of matters that I'm not going to read out, but I think in terms of the sequencing that the standard sets up, it's a clear signal that you don't end the ICB decision part of this by doing the noise modelling and then adding in terms of the ICB any land that is zoned for port purposes. You go beyond that to reflect these various planning considerations. And so that's why I say there is something of a circularity here, because what I've said is you have to make your zoning decision in order to undertake the front end part. But then clearly the standard is signalling that you have to take account of some broader planning considerations at the tail end as well. And that's really why I landed where I did in response to questions from the chair prior to the adjournment about perhaps the way to undertake these tasks is actually to put aside whether one is making a zoning decision or one is making a decision about locating the ICB, and simply start from the ground up with effects assessment and use the material that comes out of effects assessment, and by that I'm including reverse sensitivity effects, clearly, to then guide both of those in the same way.
Yes, I'm just taking notes on that. That was my understanding of what you did say prior to the morning tea adjournment. The next question, as part of this suite of questions, is if we tackle the zoning question first and we come to the conclusion that the port zone is the most appropriate zoning to give effect to policies and objectives and the provisions of the RMA in terms of sections 32 and 75, does that by default then determine the position of the ICB?
In a sense, yes. I'm answering bluntly because I think that deserves a blunt answer. And I say in a sense, only in that what you mean when you use the phrase by default is that's what the New Zealand standard would require the outcome to be, I think.
Yes, and I'm going to your paragraph 15 and your opening, your supplementary. So your 9th of August from this that you started yesterday, and you quote there from the standard, shall encompass the area of land or water shown in any local authority plan as an area for port purposes. That's the reference you're making, presumably.
Yes, it is, and not just there, but also, of course, the figure 1 that I took you to yesterday, which is how I derive my understanding of what that phrase means. But I think the short point is, yes, I think if you were to arrive at a decision on the zoning first, if that was the sequence you decided to follow, and you were to conclude that the appropriate zoning for this site, viewed through all the relevant statutory lenses that you need to, is port zone, I think the outcome that the standard then drives is that the ICB should remain located where it's shown in the notified district plan.
Yes, and just to complete that question, that would be notwithstanding what the noise levels are shown in relation to that site might be. So for example, if the site is own port, but the noise levels predicted are not at the 65 dB level, then in terms of the quote in paragraph 15, do we go to whichever is the greater? Is that the guidance that the standard is providing?
Yes, it absolutely is, and the visual example of that is in figure 1,
yes.
which is the exact description, which is the exact situation just described. It's
Yes.
It's got the orange highlighted plot of land is beyond the 65, so it means it's getting less than 65 dB. But because it is zoned for port purposes, it has been included inside the ICB in that example.
Thank you, Mr. Slyford. I understand that. I guess what one thing that I'm just not unsure of is that on one hand, the standard is a guide, but on the other hand, it uses mandatory language. So at the beginning of the quotation, at your paragraph 15, it begins with shall encompass the area. Are those two matters at odds, the guidance aspect of the standard and the use of mandatory language in the standard?
Well, I don't think that they are. I think it's worth observing that the standard uses both shall and should, and Mr. Fitzgerald alerted you to this in his evidence that there is a distinction within the standard itself about things that are mandatory and things that are not, and that's signaled by those language choices. But I think the position that you occupy on this panel requires you to not treat the standard as the be all and end all. And it's in that context that I accept that the standard is guidance as a whole. Nevertheless, I would say that the guidance here is very strong, and unless there were extremely good reasons to depart from it, I don't. It was not an outcome that the port would support.
Okay, I'm just carrying on in terms of this first question. If we determine that the area is most appropriately zoned port, and we set the boundary of the ICB accordingly, really that's, I mean, to use colloquial language, that's the end of the matter. Do not pass go, do not collect $200 approach, isn't it?
Well, I think without necessarily wanting to endorse the monopoly analogy, I think it reverts to a commercial decision about what happens next, and as the chair, I think, rightly observed before the adjournment, that's a matter outside your scope and your consideration, really. It's not for you to second guess that in some ways.
Okay. Just want to now move on, as all part of this question is to the converse situation. If we find that the most appropriate zoning to give effect to the objectives in the high order documents is not a port zone, and it's some other zone, presumably that therefore means that the seaport site would, by, again, I'm going to use the word by default, fall outside the ICB unless there was some noise evidence to indicate otherwise. Do you accept that proposition?
I can tell you that the noise evidence that the port has presented accepts what you've just described, that Mr. Fitzgerald has said, if the zoning were to be mixed use or whatever one might, describe Seaport's outcome as, not, then he concedes that would mean the ICB would get drawn on the seaward side of the Seaport site.
Okay, let me just ask that a different way. Would that mean that the Seaport site would be between the ICB and the OCB?
Yes, it would.
Thank you. So that situation I've outlined is a pretty binary situation based on determining the zoning first, isn't it?
Binary in the sense that how you decide the zoning seems to dictate the outcome of the ICB location. Yes.
Okay. I'm just going to conclude by one final question, Mr. Slifold, and that's just to take up your invitation to the panel to perhaps put aside these matters that we've just discussed and approach it from an effects basis. I think that's what you said just earlier. And to that extent, I'm just wondering aloud whether a decision on the ICB based on noise evidence in the first instance as an effects surrogate might assist in a zoning outcome following that determination. Do you understand that proposition?
I understand the proposition, but I don't know that I can help you with an answer to whether I think that is the way that works or not. And I say that, and I'm not trying to be, I'm not trying to sidestep it, but I haven't addressed it from the standpoint that you would decide the ICB first. And I don't have Mr. Fitzgerald's view in isolation from zoning about where the ICB should be located.
Okay.
I don't think I can take that matter further in the absence of expert evidence from Mr. Fitzgerald that looks at those matters as a noise expert in that way. And of course, that's only looking at it from the noise perspective, not the broader planning considerations.
Yes, I understand that. The reason I've put these series of questions to you is I think it's probably clear. I think they're quite critical. And it's also possible that the sequence we approach them in may determine the outcome. I also put those questions to Mr. Nolan on the first day of the hearing, because in his legal submissions, he had indicated the same sequence that you prefer initially. And I asked him about reversing the sequence. He was open to that in my recollection, but I don't think he had a strong preference either way. So there's not necessarily a question there. I'm just trying to provide some context to the reason I put these questions to you.
Yes.
Unless you want to carry on.
The one thing that I might just shine a light on is I think the reversing of the order that you're positing, where you decide the ICB first and you decide that on as a result of making an effects-based assessment. Although I don't have Mr. Fitzgerald's view on that, I think what that actually entails, if you pull it apart, is in a sense you're using the ICB as a proxy for
I was going to use the word surrogate, yes.
Yes. And I guess what I would say about that is you do have Mr. Fitzgerald's view about the inappropriateness of an outcome, whether it's driven from the zoning or the ICB location, an outcome that provides on a large scale for residential activity on a site that receives 55 to 58 EV. He does not support that outcome.
Yes. Just on that, and I appreciate this is a question for Mr. Fitzgerald, but based on your understanding, is it merely the fact that the noise levels are greater than 55 as opposed? I mean, if the noise levels over the site didn't exceed 55, presumably Mr. Fitzgerald would have a different position. I appreciate that.
I would be guessing.
Yes, but from your understanding of the concept that he's portraying.
It is my understanding that that it's dependent on the upper part of that range, the 55 to 58, that leads him to the view that it's a compromised noise environment. And I'm also conscious that sitting in behind that from Mr. Fitzgerald's perspective is that he had, even if you take out the problematic reach stacker and container lift and so on, he says he's still dealing with the most dynamic port that he works for, and he's also at pains to emphasize that the modeling exercise he's undertaken is not the future, it's a future. It's only a representation of what might come to pass. And so I'm saying those because I think those are important elements to keep in mind in relation to this idea that we're pinned to 55 to 58. What the noise experts have agreed is 55 to 58 is, according to the modelling, the noise that's received there now. And if nothing were to change, the modelling would assume that amount of noise into the future. But that doesn't necessarily mean that Mr. Fitzgerald is anticipating no change and no increased noise either.
Yes, I understand that. Thank you for that clarification. I'll wrap it up with this final matter. And it's in two parts. Firstly, I think I'm hearing from you that whilst it's your preference and suggestion that we approach the sequence from a zoning perspective first and then an ICB, there's nothing to prevent us doing that, the reverse. That's the first point. Can I just get a quick response on that?
That's correct.
Yeah, and secondly, the question I have for you is, would a decision on the ICB based on noise evidence actually assist in the zoning outcome? And let me just elaborate on that. Would it assist in the sense that it is a factor to be taken into account in the zoning outcome, but not necessarily the only factor?
It could do, but I can't entirely disentangle the two with quite that degree of ease. And what I'm meaning by that is the decision on where to place the ICB plainly isn't just a noise-based decision. It plainly incorporates some zoning considerations. And so I am very much tempted to use either your word surrogate or my word proxy to describe what you'd be doing if you made the ICB decision first. In some senses, you'd be just making all of the decisions together. I would say, because I think some of those broader considerations that I mentioned at 647 of the noise standard that apply to the ICB setting are the very kinds of things that, or some of the very kinds of things you'd be thinking about in terms of the broader zoning assessment.
Yes, thank you. That's I just for the record, I haven't asked any questions on scope, and that's not a reflection of anything. That's probably a reflection that I understand the position that you're putting forward. Just in case you're interested, I've taken some 10 pages of notes on that during the presentation, with the cross references back to the council legal opinion and the legal opinion by Seaport. So that's something that the panel needed to dissect carefully. So, but no questions for me on that. Thank you for your assistance. So that's all from me, Stephen.
Thank you, David. Been the longest legal discussion we've had in these hearings, but you know, as I said before, it's quite important that we do. Yes, now we've got these 3 legal opinions.
Yes.
In front of us. Okay, so
Mr. Dingle is going to present, and you have a statement from him. What I thought would actually be a useful way to start, though, is we've clearly had a lot of information from Seaport over the course of their presentation about other ports, about Auckland, Napier, Wellington, and so on. And I thought, as a scene-setting exercise, if Mr. Dingle could take you to some visual materials, just to orient you about this port.
yes,
And how it's set up, then he'll start with that, and he has a video that can be played, and he can talk as that is playing.
okay.
Just going to reposition myself.
Look, the other thing before we get on with this is we have had some feedback over the break that the people listening in are still struggling to hear. So I'm going to have to make a conscious decision to speak really closely to the microphone. And Ross, if you could kindly do the same.
That's my that's force management.
Will David have those?
He probably doesn't, but it's just my notes in terms of speaking to the evidence.
Yes. So we'll get those
Get them to
on the same. While we're thinking about this, the noise standard itself, I'm not sure we've got that completely in front of us, and I know probably why, because it has all the big copyright stuff that you go to jail if you circulate it. Hamish,
I'll find a way.
can we without risking going to jail, I think.
I think that's the prerogative of the chair, Stephen.
Oh. Well, for the question then.
Take one for the team.
Good morning, everybody. My name's Ross Dingle, and I'm the head of commercial at Port Taranaki. That's a role that I've held for 3 years. I've attended the following hearings: hearing 5, natural features and landscapes; hearing 8, the coastal environment; hearing 12 on hazardous substances; and hearing 20 on the port zone. In preparing my evidence for this hearing, I've discussed the rezoning chapter with Ms. Carter, Mr. Fitzgerald, and Mr. Slyfeld. And as Mr. Slyfeld mentioned, I'd just like to start by presenting a short video showing the port zone land and how it is utilised for Port Taranaki activities, and how within the port zone itself, within the port secure area, where effectively we're fenced in, we are bursting at the seams. I think it will provide a useful overview in support of my evidence. I'll then work through my evidence and would like to focus on certain aspects of my evidence, which I think will assist commissioners address the issues that we're wishing to resolve through this process. For this purpose, can we please take my evidence as read, and I'll focus on the following matters: the port economics, non-port land ownership within the port zone, port land strategy and opportunities for growth, and the social license to operate. So I'll start the video now. Now, this is going to be interesting because I'm going to stop on occasions just to provide some commentary. Here we go. Okay, so what we're looking at here is the Port Taranaki Centre, which is the corporate, effectively, office of Port Taranaki. It is on Bailey Road, which is the road that you go down to access Ngāmutu Beach. We have other tenants in our building, New Zealand Customs and EPI. And if we just advance very slightly, we can see the Seaport Land Company on the right-hand side of the screen, their land, which is about 70 metres from our office back door.
Is that, sorry, Hamish, is that, what's that office block zone?
Port zone.
That's port zone. Yeah. The port zones are allowed, offices like this are allowed in the port zone, or is this obviously quite a departure, particularly?
Double check that, just in terms of the which precinct the balls are in.
Yes, okay.
And what we're now looking at is a view effectively from the harbour entrance. And on the left, you can see the lee breakwater. And within that environment, we've got the kids fishing jetty, which is just located in this area here. And of course, the public boat ramp. So both these facilities are made available to the public by Port Taranaki and maintained on behalf of the public by Port Taranaki. Also within this image, we have a number of moorings which are available to members of the public to moor their boats. And then if we come have a look at the left-hand side of what I'd describe as the eastern reclamation. So if we go left or east, we can see we've got a number of buildings there. Typically, they are what I've described as mixed use. So we've got about 4 cafes and eateries in there. We've also got some commercial space, which is organisations like hunting and fishing. There's a boat, Tasman Marine boat repair business. And also we've got other users in there, like the New Plymouth Sports Fishing Club and the local Coast Guard. So that area itself is certainly open and used by members of the public. And if we just follow the cursor just along here, this is the commencement of the New Plymouth Walkway, which is the access point effectively from the port into the central city along the walkway.
Yeah, we just pause there, Ross. Is this two questions? I don't multitask during hearings like Commissioner Littlejohn does and follows all the zoning on his laptop. So the zoning of that mixed use area, Hamish?
That's port zone,
In port zone.
and then there's the precinct plan where that area is the mixed use precinct in the port
Okay.
zone.
So it allows for activities that are mixed use type. So there's already a mixed use precinct in the port zone.
That location that Mr. Dingle was just described is where it lies.
And that's, my thinking is going towards 7th precinct. There's already an example within the port zone of a mixed use zone type precinct. And the second
Even if-
question, is this?
Oh, sorry.
If it's on the same topic, you go ahead, David.
Yes, sorry, I just wondered if Mr. Wesney could tell us what the precinct notation is for that area. Is it A, B, C, D? Isn't that the notations? E, thank you. That was all, Stephen.
Second question. Yeah, great. Second question, Ross, is this the area we're looking at that's been thought about in the past as a marina locality?
So the marina in the past has been reviewed in this particular area here.
Yes.
Under the Rod Marler plans, I think it's kind of brought out into this area out here. Is it okay to continue? Yep. I'd also point out our launch operation, which is effectively where the marine pilots access our two port launches, the Rowinia and the Mikatahi, to go and board vessels coming into Port Taranaki. And then I want to focus on this area here, which is the Eastern Reclamation, and you can see two fairly significant structures or buildings there. On the left is the former Fitzroy Yachts building, which is now utilised for the construction of smaller homes. They get constructed inside the building and then put on trucks and moved away from the port. And then importantly, this building over here, which is the Viterra grain store. The Viterra grain store has been there for many years. It has in the past been a store for PKE. Due to complaints about odour and dust, Port Taranaki took the decision to remove the PKE from that facility and take it over to the New Plymouth Power Station site, and I will explain where that is shortly. But in terms of proximity, that is not too dissimilar to the proximity from the Craig Norgate store, which I'll show you shortly, to the border of the Seaport Land Company site.
What's happening in here now?
That's now used for storing different types of agricultural stock feed, grains and other products, but not PKE. Once again. Stop it there. So this is now the port entrance into Port Taranaki. It's really Taranaki's gateway for trade, not only to other New Zealand destinations, as I'll describe within my evidence, but also to the world. It's a small area that's necessarily located on this part of the coast, and it's a really important access point for Port Taranaki's customers, who I'm also here representing today. It's extremely important that we acknowledge that the purpose of the port is, of course, to make trade easy for them and make sure that supply chains are operating very efficiently and effectively so that they can trade with the rest of the world. The channel is dredged to a depth of 12.5 metres, making Port Taranaki the only port on the west coast of New Zealand that is a deep water port. Extremely important and strategically important in that regard. In the background, you can see the Motu Islands, Moturoa, Wharimanu, Toko Mapuna, and Motu Mahanga.
Ross, the alignment of those breakwaters have been carefully engineered. Do you have these longshore wave problems in the port that other ports do? Or is this safe at all times to come in and
talk about long period waves shortly, and the short answer is yes, we do have long period waves that come into the port and impact our ability to safely berth vessels, and in fact we have to send them from the port to wait out periods of infogravity.
Okay, thank you. So you'll cover that?
In this shot here, we're now looking back towards Port Taranaki from the main breakwater. And just in terms of context, we've got all our berths over here. You can see the Seaport Land Company site just in behind the Ngāmuti Beach there, very close proximity to the port. And I'd actually make the point that there's been a lot of talk about Port of Auckland through this hearing. There's been a lot of talk about the Wynyard Quarter. In my mind, it's very difficult to draw a comparison between the two ports. In my mind, the Wynyard Quarter has been characterised by fishing vessels and marinas quite some distance from the operating port of where containers are actually at the other end of the Auckland CBD. And also, in my mind, the horse is kind of bolted in Auckland. The port has sold off quite a section of land, so it can't really expand anymore. And now we're seeing in that location a pressure for that port to move out of Auckland completely. So I'll just make that comparison. Also, if I think back to the Wellington situation, in this, I feel like the proximity of Seaport Land Company land is a lot closer to maybe some of those residential areas in the Wellington example, which have the Westpac Stadium in between them and the residents. So I just like to make that point. Okay, so at Port Taranaki, we have 9 commercial berths, and I'll quickly describe those. Where my cursor is now, this is called the main breakwater. There's 2 berths there, and that is used to support the offshore oil and gas industry. Immediately adjacent to that berth, we have the Motoroa berth, which has 3 berths available. As you can see there, our tug fleet keep safe harbour there, but also some fishing vessels will utilise that piece of the port. The main Motoroa berth 1 and 2 are used for the discharge of typically bulk dry products, so the agricultural feeds and fertilisers. And as I move further inland, we have the Newton King Tanker Terminal. This is the jewel in Port Taranaki's crown. It's our most important asset. We do circa 5 million tonnes of product every year through Port Taranaki, making us the 3rd largest bulk export port in New Zealand. And interestingly, in Mr. James's evidence, trade never got above 4.5 million tonne for the last several years. Well, that's just not correct. If Mr. James had taken a look at Port Taranaki's audited financial statements, he would see that every year for the last 5 financial years, we've exceeded 5 million tonnes. So there was a bit of a problem I had with that. So our typical customers in this space are Methanex, who are our largest customer, and other oil and gas companies like Todd, OMV, Greymouth Petroleum, Beach Energy, Liquid Gas, etc. If we move across, we then see the Blyde Wharf. So the Blyde Wharf has berth 1 and berth 2. Now this is used to be a container terminal. It is now a log terminal, but it's also quite specialised at this end in Blyde 2 with a heavy lift pad, which allows us to accommodate some extremely large project cargoes like wind farm and wind farm blades, which we've had through the port on a number of occasions in the past.
You had large transformers and big heavy loads going to power plants?
Yes, we have. So a number of items for, say, the Methanex development have come through Port Taranaki.
Let me just to get my context, is that Katahi just on the top right of this green?
You see that where my cursor is? Oh, actually, my cursor's been delayed here. There it is. Yeah.
Yes.
I think that was perfect.
The Methanex tanks behind.
That's correct. Yeah, there's 2 Methanex tanks and there's 3 former New Plymouth Power Station tanks in that area. And that draws me to the big red turbine hall. Here. Yep. That is the former New Plymouth Power Station turbine hall, which is now where we store PKE for Waitera after removing it from the Eastern Reclamation following those odour and dust complaints. So in context, Port Taranaki services roughly 270 cargo vessels per annum, and we have circa 450 vessels into the port, so that the balance is typically offshore support vessels.
Cargo vessels, over four,
Around 450
50, and the balance of the
offshore support vessels.
vessels coming and going.
I'd also point out, cursor gets me over to there, is the Craig Millgate store, which is where large volumes of PKE is stored for one of our key customers, Agrifeeds, which is about 75 metres to the Seaport Land Company boundary. And the other thing I'd point out are our two mobile harbour cranes, so you can very large structures. There's one there, and then there's one over on the right of the screen. So a couple of key pieces of port equipment used for formerly for lifting containers. But as the nature of trade's changed and we no longer use containers, they're often used for the offshore support vessels to get product out to the Maui and other licence areas, but also if a wind farm or wind farms come through, we will use them for twin lifting blades off those vessels.
Thinking about the fertiliser, with the closure of the Ravensdown plant here, are you receiving superphosphate in that all trucked from the other Tauranga and Napier plants? You mentioned fertiliser and First Wharf.
So we have some fertiliser come in, but we have balance will export
Exporting.
out of our port.
Okay.
I move through to about 38 seconds. So just another couple of views of the general port. Tudu in the background. Stop it there. And really what I want to focus on here is this particular terminal, which is now utilised solely for log storage. So Port Taranaki supports 4 log exporters. There's been strong growth in logs over the past several years. We're now exporting circa 1.1 million jazz of logs across our port annually. And in terms of growth, that represents about a 62% increase over the last 4 years, where we've gone from 679,000 jazz up to 1.1 million jazz. You can see the Seaport Land Company land just in the left of the screen into the port. And I think the other thing I would illustrate here is that although the log yard doesn't look particularly full at the moment, that's simply because there's been a couple of log vessels, and on any given day, that particular log yard can go from being extremely full to looking like it does in this image. And that creates some issues for some of our exporters because of the space constraints on the port that we have. They can be locked out, meaning that they're unable to bring additional logs into the port. And when we think about alternative uses for the Seaport Land Company site, which I'm sure you're going to ask me about, I'll preempt that by suggesting that if the issue is the buildings, that site is actually quite blessed by having a rail line right past it. And as the government thinks about changing modes of transport and decarbonisation, I think it's quite likely that we'll see more logs on rail. And there's quite a nice potential for a site like that to be utilised as a place to bring logs into Port Taranaki, as if it would remain port zone and if residential was unable to occur there.
Are you suggesting that the buildings could stay and you'd work
The
logs
logs
in
would
it?
have to be, or at least some of them would have to be removed to accommodate that. I've got some other uses too, which we can explore later.
So if I was coming out tomorrow, which I am, to look around the port,
Yes,
the log pile could be quite different.
it could be.
Yeah.
I'm just going to move forward. There. So I just wanted to highlight some other areas on the port that are of interest. If we start in the bottom left, so this bottom left area is typically dominated by a couple of things. First of all, Kiwi Rail land with a number of sidings that are currently unused coming in and down through this area here. So this is Kiwi Rail land, and the rail line stretches right back up, right past the Seaport Land Company. In addition to that, there is one rail siding which swings around in past these silos here and straight up onto our Blyde Wharf. So it's actually one of the only wharves in New Zealand that has a rail line that goes along it, which enables us to bring logs in daily from the Whanganui region for storage at Port Taranaki. Down in the bottom left corner here, we've got...
Just to clarify evidence, there's daily trains coming in to that site, unloading onto the logging storage site.
That is the plan. Now, there's a couple of things that can prevent that from occurring. If we've got a vessel on Blyde 1, we can't park a train on Blyde 1, it would then go and park on Blyde 2. If we have a vessel on both Blyde 1 and Blyde 2, then we can't bring a train in on that particular day. And if Kiwi Rail has some issues with rolling stock, then they may be unable to supply the wagons required to get the logs from Whanganui to New Plymouth. So the desire is to have a daily train during the week, but sometimes operationally that's not possible. So it does actually raise the opportunity for other log storage space in other parts close to the port. Utilising that Kiwi Rail land and port land and potentially Seaport Company land in the future. I'd point out down in the bottom left-hand corner here that we have two bitumen production facilities. So Road Sciences and Technics Bitumen operate in that area. We also have tallow and molasses which come through the port as well in that area.
How old are the bitumen plants? Because they're being modernised and placed all over New Zealand with new facilities. Are these state of the art or are these older style ones?
The buildings themselves are older style, but some of the technology that's inside the buildings is quite modern.
Okay.
I'd also point out just in this area here is the liquid gas LPG facility, which has been the subject for some discussion. The Craig Norgate store, operated by AgriFeeds. Over here, we've got the Regal store, operated by Regal, and the Seaport Land Company site, and of course the Port Taranaki Centre, which is the first image that we saw when we were driving down Bailey Road.
Can you just leave this image up? And I'd like to ask Ms. Mako, can we see the area for the new rye development that the able was working on?
I can actually
Can
put
you
my
point
cursor
it out? You know what? That's the area there where your cursor is.
please.
Yes.
So all of that green is on all of the ground, open space area.
So we've had a concept plan prepared for us and delivered as a key precinct through there. I just wanted to understand that in relation to the other report. Eastern information in your own mixed use
That's
commercial area that's further.
It's the Eastern information, and just to the top of the image there, it's the mixed use area.
I think it's a great image for us. But could the port give us a copy of that, or obviously the video, but also the still of this view. I think it's
Yes,
really quite important for us, so that would be really helpful, just as a A3 PDF or something.
Just want to make another couple of observations here. The first one is this entrance here at Hickarau Road is actually the only entrance onto the Seaport Land Company site. I just wanted to clarify that because in Rod Marler's drawings, he indicates that there's other entrances and exits from the site. What's going to end up happening is this quite reasonably busy piece of road is going to be utilised for getting residents, if the plan goes ahead, into this area here. But also in the images, and I've got one of them here, which I brought along with me, which was in Rod Marler's evidence. It's page 40. It's 5.11 access and circulation. It refers to three different, that's my undertaking, vehicular access entries, it says, three separate places. One is in the, how would I describe that, the southwestern corner, which is this point here, and that's correct. And then there's also an entranceway just in here somewhere. In fact, there is no entranceway that's directly onto Port Land. And the other entranceway is up in this corner here, which I've described as the northeastern corner. That would also be an access directly onto Port Land. And then finally, in the drawings, there's a primary pedestrian route, which effectively comes right between these buildings here somewhere, once again, straight onto Port Land. So first of all, there's been no consultation with the port in regards to whether those access ways are appropriate. And I have some major concerns, and I'll go through that right now, actually, because in my evidence, I submit that the port is a very busy place. And as I've tried to demonstrate, there's not a lot of other areas to develop within the port secure area. And we are working with a company called Move Oceans to facilitate a coastal shipping route between Plymouth, regular coastal shipping route between New Plymouth and Nelson. And I think it's really interesting, actually. In the last few days, we've seen a lot of media about road closures around the Nelson area. So this particular opportunity creates some significant resilience for that region and our region to transport product. Now, the reason why I want to talk about this is because the berth that we would like that vessel to use is actually the Blyde berth, which is at the end of this Blyde area here, shared with our logging customers. And the most efficient way and safest way, actually, to get vehicles to roll on and roll off that ferry, that service, is for them to marshal. And this would be our marshalling area, which is this piece of road here called Refinery Road. And you'll notice that it's directly in front of the Seaport Land Company site. The idea is that the way that the coastal shipping plan is being developed is that Move Logistics, who we typically associate with trucking, sort of vertically integrate in the supply chain, which means that they'll be able to have their trucks load onboard this vessel. They'll probably be able to fit about 40 trucks and trailers on that vessel. So it's got about, the one that they're looking at the moment, it's got about 1.2 kilometres of laneway on it. Only about 10 or 11 of those trailers will actually have a truck attached. They'll bring it to the port, and then they'll use a vehicle called a Maffey to take those trailers off and then collect trailers that would be parked up here and take them through the Eastern Rec quite quickly along Blyde Road and onto the vessel. Now, the thing about that is, well, why can't we use a different area in the port to do that? Well, once you start doing that, you start having vehicles moving past and around all these log sites with heavy beak loaders and other creates traffic management safety issues for us. So that's a really efficient way of doing it. That, in my mind, will create noise at all sorts of different hours of the day.
Okay, so perhaps when you give us the aerial plan, you could mark up.
I have actually marked that up in my evidence.
Okay.
So in my evidence dated the 26th of July, I have attached an appendix. It's called Appendix 2. And you can see there I've marked in red an area called roll-on, roll-off coastal vessel truck marshalling area. And that's really the significance of that piece of road. Now, I want to also now point out across the road. In this area here, if you drive past that today, it looks a little different for two reasons. One is that it's the site of the Waitomo petrol station. And secondly, there's quite a significant development happening in behind the Waitomo station, which is happening today. And that is the movement of one of our large marshalling and stevedoring companies. In fact, we're just going to focus on the marshalling aspect, ISO. So ISO currently are located in this shed here. And the idea is that the logging trucks come into the port, they go through that scaling facility where the logs are measured, and they're then determined on what part of the port they will be delivered to. So ISO are automating that process. And what they've done is they've leased a piece of land up in here. And now, so what will happen is that the logging trucks will come along Breakwater Road. They will slow down and brake, and then they will turn left onto this property where they will move up and they will go across a weighbridge, which obviously records the weight of the logs on the truck. And then they will go through an robotic scaling facility, which is a really fantastic piece of technology. It effectively sends a camera down the back of both trailers and it scales and measures those logs within about 3 or 4 minutes. And then the trucks will then depart this site. They will turn left onto Breakwater Road and they will accelerate away. So now in this situation, and I've also included that site in my appendix 2. So now in this situation, the Seaport Land Company site is effectively surrounded by, I want to say port activity, but it's certainly by operations that are directly as a result of the location of the port.
Your appendix 2 outcome into his noise modelling?
He wouldn't have factored in the roll-on, roll-off coastal vessel truck marshalling area.
But he would have factored in the ISO log scaling and weighbridge and accelerating.
I'm not sure that he would have because it's not in port zone land.
Yes, that's my question.
Yeah.
And because it's not in port zone land, it doesn't count for port modelling. Is that your understanding?
That's my understanding. Yes.
The green area in front of the coastal vessel truck marshalling,
Yes.
that's a reserve area, is that right?
That's Port Taranaki owned land.
Yes.
And that land is available for port activities.
The port zone.
It is in the port zone. But if you think about reserve land, I'd actually point to this piece of land through here, which is Ngāmuri Beach, which the port has made available to the community as a community asset. And if you go down there on any particular day of the weekend, you will see children playing, you will see people fishing and jet skiing, you will see quite a lot of community activity in that space. We also support the New Plymouth Yacht Club and its facilities down there.
So it's in its own precinct, I presume.
A precinct within a precinct. Yeah, I don't. So we lease it to the New Plymouth District Council, and they maintain that area. I guess I'd also just point out, there's quite a lot of equipment, difficult to see, but let me just point out a few things. So here we've got a Cinnaboggan, which is a piece of machinery used for stacking logs, and we'll see that shortly. Actually, over here, I'm sorry, it's not very clear, that's a reach stacker. That's one of the port reach stackers, so that's been the subject of a bit of conversation lately. We've got some trucks going in and out of the port. Down here, we've got some port hoppers utilised for discharging bulk dry from vessels. There's a lot of dynamic activity and equipment being utilised in the port on any particular day.
Okay, but could I just ask again? This is why this particular image is so useful. I'll take a step back to your access position.
Yes.
So your position is that 2 of the 3 accesses that Mr. Mahl has shown traverse port land, and the only way of enabling access into development that's been proposed would be with the commercial agreement of the port.
That would be correct.
Yes. And your second comment about no request or consultation about that, we've had evidence about the consultation process, effectively that the port was not that keen to engage in that sort of detail because you had a fundamental problem, these are my words, with sort of the concept as a whole. So would you disagree with that, or do you have evidence that there's been any open mind consultation, or is it really that you just feel the threat of this sensitivity so great you just don't want to engage?
I'm actually going to read out a statement that will hopefully answer that question. So it was.
Is that part of your evidence?
Yes, it is. Yep. But I want to sort of just voice that. So before I start, I want to note that in previous discussions with the Seaport Land Company, including at the consent hearing July 2020, and as discussed with Mr. Kisby and Mr. Nagel, and as stated in my evidence, Port Taranaki has consistently acknowledged the innovation and vision of the Seaport Land Company's proposal. That said, we have throughout maintained our view that locating residential apartments within the port zone or industrial D zone is inappropriate and creates potential and actual adverse effects on noise, light, spill, dust, and odour from Port Taranaki activities. So it's not that we have been obstructive, but what we've said is we've got a particular issue with residences being introduced into that zone so close to the port.
Okay, thank you.
It's going to move through to about a minute. Okay, so in this image here, we see the port main gate. So this is right at the end of Breakwater Road. It's going to advance just even slightly further. Yep. So a couple of observations here. Once again, we've got the Kiwi rail yard. So it creates this kind of V. We can see that the logs are nicely positioned actually on Port Taranaki land. More log space, quite full. Also, a number of items of equipment that get utilised in port activities. And the entrance to the New Plymouth Power Station site is through this roadway here. I would estimate that the port receives about 45,000 trucks per annum through that gate, the bulk of which are for logs, and then we have a number in the thousands, 10 to 15,000 for our bulk dry customers. Then if I advance it just a little bit further, in this image here, I just want to point out in the bottom left, we have the Methanex facility, which is a major hazard facility, not owned by Port Taranaki, that land. So I've pointed out, I guess, a number of pieces of land within the port zone that Port Taranaki don't actually own. There are others. In addition to that, we've got these sheds down here, which have recently been removed. Those are where our wharf services team are housed. They need to be there. They're in charge of mooring and general port operations and a key part of our team. And then we spoke about the ISO scaling facility. Well, we do have another scaling business on the port called C3, and that's their scaling facility there in amongst a log yard. We continue forward.
But just for our record, what's the date of the video, Ross? When was it?
It's dated at various times.
Okay, so it's been put together. All right.
Okay, so this is just an image looking directly at our New King tanker terminal, and these big structures that you can see are loading arms. They are used by companies like Methanex, OMV, Beach, Greymouth, Petroleum, Todd, and we have pipelines for liquid gas. So the thing about that, as I'll explain in my evidence, is that a lot of that product's transported by pipeline, which is kind of quiet, silent. You don't really hear it, but it's incredibly important when we talk about noise. I'll come to shortly. You asked about infogravity, so I'm just going to stop. There. What you can see here are shore tension units. Now, Port Taranaki was probably one of the first ports, I think, in New Zealand to introduce, and possibly still, there might be another port using them now. These were imported from Europe. And what they do is they use hydraulic arms to allow the management of vessels on the berth. You asked about long period waves, which we do experience, and even at this time of year, we see them quite regularly. This allows us to maintain the vessel alongside wharf for longer periods of time without, well, there's still a risk of snapping lines, but it kind of reduces that risk. And what we've found is that we've been able to keep vessels in longer during periods of long period wave activity. Obviously, safety is still extremely important. So as we get to a particular size of swell, and I'm starting to swim outside my lane a little bit here, we will let them go for safety reasons, and we let them back into the harbour once that long period wave is reduced and it's safe to bring them back in.
Well, I guess with the port I'm familiar with that has big issues with period waves and need ships to come and go. But I haven't seen this type of system here, which looks pretty innovative.
You can also see in the background here a couple of large eco hoppers and some grabs being utilised to unload this vessel. Units. Grab. Discharging that vessel. Just another shot back through the Blyde Wharf area. You'll notice that in behind the port, there's quite a lot of industrial land, which historically has been used for storing different types of fuels, crudes, condensates. Some of it's still used, some of it isn't. And then beyond that, it's quite an offset as we have some residential property up on Mount Motoroa. Forward. Activity. Just stop it there. So what we're looking at now is Port Taranaki's weighbridge and log gantry. or truck gantry. So the gantry is used by logging customers to lift their trailers onto their trucks, and the weighbridge is used for weighing product on trucks. So it can be logs, it can be dry bulk, it can be project cargo, it can be scrap metal. But I guess what I'm saying is that within the port operations area, every piece of land is kind of has a purpose and is being utilised. We don't want to get ourselves in a situation where we are hamstringing our capability to extend port operations.
I was going to ask the question at the time, but you had an image a bit further back with the log area, not on the Blythe Wharf side, but where you showed us those two green buildings that have been taken away.
Yes.
And it seemed to me that there were little corners of wharf area that were being used for log storage. So is that a graphic illustration of your point that you're using every little bit of land you can?
It is an illustration of that point, yes. And the other illustration would be that, our 4 exporters have been locked out, each of them, between 7 and 11 times in the last 12 months because we've run out of room. Now, it's a bit of a double-edged sword. You can run out of room because your port's not big enough, or you can run out of room because the exporter hasn't brought a vessel in on time, or you can run out of room because with the best intentions, there's been a shipping delay. So you're kind of, in those situations, you definitely are bursting at the seams and looking for additional space.
I'm aware in Naples, for example, there's a lot of storage spot. So that's being brought in and marshalled and then off the port. You said there was quite a lot of industrial land up the back and changing from hydrocarbon economy to other economies. Would it be fair to say that there are areas around about the port that you could look at expanding those sorts of facilities on?
For an exporter, that's very much a plan B, because then you start getting into the realm of double handling logs onto trucks, and that becomes quite expensive. So the ideal situation is to have the port very close to the wharf and the logistics supply chain moving as efficiently as possible to load out as more logs are loading in. Just about there on this. We're going past the C3 facility. And just another couple of items of equipment that get utilised on the port. This is the beak loader. These beak loaders are obviously driving around the log yards and crossing some roads. When I think about the roll-on, roll-off piece, we want to try and avoid those areas where there's a potential for conflict. And that's just basic health and safety. These are very big very big pieces of machinery, obviously carrying very large loads. And we've got a centre boggin in the background there, which is stacking the logs into space. Now we're going to actually move off the port for a second. And I just wanted to point out the BP, well, it's actually a Armada tank farm. This is a piece of land owned by the port. As the crow flies, it's probably 1.5 kilometres from the port. And this is the regional hub, really, for the import of road fuels and diesel into the region. It was previously filled by vessels from Coastal Oil Logistics, and there was a relationship with Marsden Point. That's obviously now no longer. So now we're receiving vessels directly from international ports into Port Taranaki, and they pipeline that product up to the Armada tank farm into these smaller tanks here. And that facility is leased to BP. From there, the product is then transferred to fuel stations around the region.
Does the port now have those facilities? Is it very regional? Each of the ports now import their own petrol, diesel, and are distributed regionally?
Yeah, so that hasn't really been fully resolved by the fuel companies yet. So there was, in the past, there's been quite a lot of sort of cooperation. So for example, at this site, the product comes in, we can call it like a vanilla product, and then they add their secret sauces to it, and it goes out as a BP truck or a Mobil truck or a Z truck. You see that product being transferred there. Okay, so in this image here, we have a offshore drilling rig coming into port as part of a mobilisation or demobilisation. I'm not 100% sure which. It's utilising two of our harbour tugs and an offshore support vessel. But the reason why I wanted to focus on this one is because I think it's highly likely that we will see some very large structures in the form of wind blades coming into and coming out of our port. You'll see in the press today, Blue Float, a Spanish offshore wind organisation working with local consultants Elemental, saying that they are exploring a number of offshore wind opportunities in the Taranaki and Waikato region. Once again, being the only deep water port on the west coast, that makes us the port that's most likely to be supporting that sector. And also, we've seen some press by Copenhagen Infrastructure Partners and the New Zealand Superannuation Fund talking about an offshore wind, a 1 gigawatt offshore wind park down in South Taranaki. Just to give that some context, the Waipipi wind farm, which you drive past at Waverley, that's about 135 megawatts. So one of these offshore wind farms is about 1,000 megawatts, and they're looking to put about 4 or 5 of them in New Zealand. That's their plan. Their plan is to produce 600% of New Zealand's required energy, and the reason for that is then you can then convert it in those electrons effectively into hydrogen or ammonia, which creates an export opportunity for our port.
I certainly want to ask you some questions about that possible future, and the recent news yesterday that Waikato Coast was also being looked at. I've seen the press about this ones in the South Taranaki Bight. Yes, so I just make a comment. Yes, so is that part of your presentation, or is that something we should talk about now?
We can talk about it now.
Yeah.
I have got it in there as an opportunity.
So look, my questions are, what are the activities with the hypothetical that we might have 4 or 5 large offshore wind farms, and this is hypothetical, but we're seeing the targets, basing my questions on the assumption that the 100% renewable electricity by 2035 and the carbon zero by 2050 as set in New Zealand statutes is going to be worked out somehow. So it's not a fanciful hypothetical. Would you agree with that?
100% agree with that.
Now, if we had, I think you're saying maybe 5,000 megawatts, 5 times 1 gigawatt wind farm scale, and that was used to convert or be a green energy source for green hydrogen, which again we're seeing, Southern Hydrogen Project at Tiwai Point Bluff is getting quite a bit of media as well. So what are the activities? You've shown us a NORAD coming going. So what are the activities and effects in your future scenario and port planning that you'd need to put in place to facilitate that future?
That's considerable, and I'll try and step through them. So first phase of an offshore wind farm is the construction phase. And typically what happens there is that the large components, so the turbine towers, nacelles and blades would be produced offshore, and also the piles for the in-ground turbines. If I can step you through that, today's pile is roughly 2,000 tonnes. It's a very large piece of steel that gets hammered into the seafloor. A little part of it comes above the seafloor, and those need to be brought into a port and stored somewhere, and then removed to the site during the construction phase. The same applies to the turbines themselves, so it needs quite a large laydown area. The Eastern Reclamation, which we looked at before, is a pretty good location for something like that. And in the past, Port Taranaki and our customers have utilised that area for both the Waipipi wind farm and the Turitea wind farm for the laydown of blades, towers and nacelles. What I would say about offshore wind turbines is they're a lot larger than the Waipipi wind farm.
Can you give us a scale? How much larger?
Sure. So, look, the blades for the Waipipi wind farm were circa 65 metres long. Haringa Energy, a local energy production company, is going through that consenting process for wind blades in South Taranaki. They're about 80 metres long. The offshore wind blades are more like 100 metres long. So from the sea, from the ocean surface to the top, you're talking about 330 metres. And to give you some context on that, the New Plymouth Power Station chimney is about 200 metres tall. Now, so phase one is getting the components into a laydown area, then removing them. And what happens is a vessel, a jack-up vessel, so it's got legs like that rig there, comes into port. It can typically hold 4 complete wind turbines. So that loads those on, it takes them out, and it can build them at the rate of about 1 per day. So then you've got this construction phase that happens. Once the construction phase is complete, you then move into an operations and maintenance phase that can last circa 30 years. That requires 2 different types of assistance. You've got maintenance workers who have to transit in and out of a port pretty much daily to go to the wind farms on a small vessel. But you've also got ongoing maintenance, which requires larger vessels. Once again, if you've got wind farms in South Taranaki, North Taranaki, west of Taranaki and Waikato, it kind of makes sense to use a port that supports depot draft vessels. We're the only port that can do that, right smack in the middle of those planned wind farms. So that's an operations and maintenance phase lasting 30 plus years. And then finally, if we're producing 600% of New Zealand's renewable energy, there's the opportunity to create renewable production of, as you say, hydrogen or ammonia. For the production of hydrogen, there's a huge value in being located very close to a port. The reason is if you want to liquefy that hydrogen and send it through a pipeline, you've got to freeze it to about 280 odd degrees. That's a cryogenic pipeline. You can imagine the consenting and the expense if that pipeline's kilometres away from a port. If it's close into a port, it makes the economics just so much more reasonable. Look, I'm in discussions with people who are interested in utilising port land for that, but it's commercially sensitive, and I can't say any more than that.
How much land will they? So for these hypothetical wind farms coming on board, coming and going of the components, with the Eastern Reclamation, they wouldn't all be built at the same time, they'd be staged. Let's assume that.
think it has to be staged.
Yes.
And it has to be staged because the land available to support it is limited. Therefore, it's got to be a well thought through logistics and planning exercise to make that happen. And also, I'll just also add that two of those wind farm developers are currently in the process of securing consents to get what they call FLIDARs, floating data stations in situ, so that they can start measuring the wind and swell patterns offshore. So there's quite a lot of work that has already been done in this space, and the momentum is building. We weren't having this conversation 2 years ago. This is ramping up quite quickly.
So my next questions are really around the timing. If you're giving us evidence that this is a future that the port is planning for, is it something that you could reasonably anticipate in the next 10 or 15 years of occurring?
This will be occurring at the port within the next 8 years. And the reason why I say that is because if you look at the development of wind farms globally, first of all, let's say New Zealand doesn't currently have a regulation that supports offshore wind development. So MIMBI are working through that process now, and they expect to have those regulations by June 2024. The developers are working through marine mammal studies, migratory bird studies, swell. That takes typically 3 to 5 years. So they've started that process. The actual and the consenting process, another 3 years, and then you can start building. Building only takes 3 years.
Okay, but you're assuming successful effect studies and consents, which
I am assuming that, and I'm also assuming that on the basis that the government is serious about decarbonisation.
So let's move to the reverse or the effects of these activities in terms of noise. Mr. Fitzgerald hasn't modelled this scenario, has he?
No, he has not.
And I'm just wondering if you're so bullish about this, why that's not the case.
Can I suggest that the modelling that we've done already supports the ICB as currently stated in the proposed plan?
I don't think you've answered the question very well.
We haven't specifically asked him to model that at this point.
And why not? Is that something you mentioned you've been having 2 years of discussions, and you see this as, I'm sort of sensing from your evidence to us that this is a big exciting opportunity for Taranaki. Because Mr. Fitzgerald's not here, we're struggling a bit, but with the activities we are describing, big vessels coming in, offloading big pieces of equipment, getting them back on, loading up a vessel like this we've got in front of us, getting in and out of the port, tugs, pushing and pulling, are those going to be noisy?
I think those are actually be reflected as current activities. It's kind of business as usual for us. So that element would be, but the element, say, down in the Eastern Reclamation wasn't modelled to my knowledge.
What about the hydrogen storage? Like, we're talking about massive amounts of either ammonia or liquid hydrogen that we stored at, you need specialised vessels, and I'm talking about ships here, I'm talking about pressure vessels.
That's right.
And cryogenic pipelines to bring the hydrogen onto very large tankers. Is that the future?
I think that's likely.
And
I'm not sure that's within the next 10 years, though. I think you've got to build the offshore wind first. You might start constructing those within the next 10 years. There's probably a little less certainty in my mind because we're so early in those discussions,
yes,
whether or not when that might actually occur.
But we've got modelling at 2035, so that's 13 years from now. It's possible. It is possible. And the noisy or very sensitivity aspects associated with hydrogen storage and transferal to tankers. What's the
Pipelines.
yes,
And so if you imagine Port Taranaki at the moment has a lot of product already being moved onto vessels through pipelines. So one would imagine that the noise that we currently have at the port and currently have modelled wouldn't be inconsistent with what loading of hydrogen might be.
that's what it's getting at. So I think you're saying that perhaps the difference, if that future was played out, the difference from the current noise situation at the port would be an additional of further storage of large wind farm components on the Eastern Reclamation and the coming and going of vehicles and putting things on the ground and picking them up. Okay, thank you.
Probably the other thing there is a visual thing. They're very large. It takes some considerable sort of thinking to actually visualize how big they are. They are big.
Don't have any landscape architects here, and that's a moot point. But I used to live in a house sitting above, but very interesting place to live with things coming and going. So that's probably arguable whether busy things like that are a positive or negative visual effect, depending on your perspective. That was fair. Okay, thank you. I think we're
Right.
sort of getting near the end of this.
Here we are, just about at the end. I'll just stop here. So this is the Albatross, which is a dredge. It's currently in the harbour at the moment. To keep our harbour functioning properly for our customers, we are required to dredge every 2 years. That creates the channel that the vessels can come in and around in the area that they can turn around on. I guess what we've seen recently with various storms coming through the region is that the channel's filled in a little quicker than it normally does. So our 2-yearly dredging program we've had to bring forward by 6 months, and that's why you see the dredge in the harbour at the moment. I think we'll just finish off here. This just takes a few seconds just to run through just some general port activity, pilot leaving a vessel and boarding the launch, and then the video will come to an end.
Thank you for that, Charles. Making sure that I am proposing to visit port tomorrow. Notice there's 100% chance of rain, so I've got my hopes I'm going to have to go and do that. But I think that this is taking some time, and I just said before I'm rushing. So your statements will read out. Is that right?
Yes, for parts of it, I feel like I've covered quite a lot of it actually with what we've just described.
Yeah. I think let's take a break now and have some lunch. How much time do we come back at 20 past? Is that going to be too short a time?
That's fine.
Okay, yeah, 20 past 1 will adjourn. Thank you. Okay, thank you. That video, soon we will get that to our system.
It is in your system, I think.
Thank you. Very helpful. Look, I just need to say that I'll be managing the hearing, so we finish at 4 o'clock at the very latest. We've got people catching planes. matters we need to get through. We're going to finish with Ross's presentation and questioning. We have Catherine's next presentation to us. Then we have Janice, and then we have Sarah and Julie. Ian.
Sorry, recommendation. Julie and I are obviously appearing tomorrow as well.
Yes.
So if we're short of time, I know that the right requires people as well, but Julie
Yes.
and I would be happy to talk to our evidence tomorrow.
Well, I think that is a emergency, but look, we have read all the evidence. We haven't obviously read the new stuff, but in David's, it really is putting the yards in. And again, I'm mindful, no lots of questions where I am, but so we'll manage things to finish at 4 o'clock if all things going well. But, right, so just do you want to work through what you like to give us some written evidence?
So one of my roles at Port Taranaki is to engage with those members of the community who make a complaint to Port Taranaki. In the time that I've been there, I've dealt with numerous complaints regarding noise, light spill, dust and odour. Each time Port Taranaki has been complying with our consent conditions and other regulatory obligations. That said, these complaints take time to investigate, communicate, resolve and close out. Port Taranaki has a noise management plan, which I believe has been circulated. So they also often involve the Port engaging with the New Plymouth District Council and the Taranaki Regional Council, who take an active interest in complaints, particularly when the complaint is also directed to them by members of the community. Complaints typically involve multiple Port staff from across different departments and customers engaging with each other and the complainant to get to the root cause of the matter. The idea of allowing an additional and significant number of people to live even closer to our operation and effectively on our back doorstep within the port zone is very concerning to Port Taranaki. I estimate that there are circa 118 residential properties currently situated within the inner and outer noise control boundaries. 86 in residential A zone, 7 in residential B zone, and 25 in industrial D zones. I'm a little uncertain about how many residential properties are planned for the SLC site. That said, I see some potential for the number of residents to be doubled within the inner and outer noise control boundary should residential properties be allowed on the SLC site. This material increase in residential property would also be a lot closer to the port operational area than the vast majority of residential properties currently within the noise boundaries. Port Taranaki is simply trying to avoid reverse sensitivity issues that we see playing out at other New Zealand ports, where people have been allowed to take up residence in close proximity to port activities. I'd just now like to focus on port economics. In my evidence, I respond to Mr. James' evidence regarding port economics. The key issues here are that Mr. James uses 1996 trade volumes for reviewing the schedule of port activities featuring in the table of noise criteria for setting noise control boundaries in 1998. Had Mr. James used 1998 trade volumes, we would see that trade volumes in 1998 were 4.6 million tonnes, which is a lot higher than trade in any year from 2014 to 2021.
It's a lot higher, is it not higher?
I said not higher.
Which is not higher.
Yeah, it's not higher. Yep. Port Taranaki trade is cyclical and dependent upon commodity prices. References to variances in particular years is not relevant for a business such as Port Taranaki, and not particularly relevant for establishing noise criteria, as I'll explain shortly. Port Taranaki represents a long-term infrastructure play. It is natural to anticipate variations in trade. Trade can be volatile and can, as has been shown by Port Taranaki, bounce back and grow, as evidenced by the 2007 to 2020 period. And you can refer to Mr. James's graph 4.5 on figure 2, which illustrates that jump in trade. What is more appropriate for a comparison of activity that can impact on noise is to consider the makeup of trade, and in particular, the type of trade that creates noise. In 1998, 92% of trade was across the Newton King tanker terminal. It was bulk liquids transported via relatively silent pipelines. In 2021, only 59% of Port Taraneki's trade is bulk liquid, despite the 2021 trade volume being higher than in 1998. 2021 has significantly more trade from activities that had more noise associated with them than in 1998. In 1998, noise contributing trade, and I'm going to use bulk dry because that's what it would have been, was about 370,000 tonnes. This could have been transported on 9,250 trucks. Compare that with 2021, where 1.8 million tonnes of logs and bulk dry is transported on circa 45,000 trucks. A key noise determinant is not only activity expectations, which Mr. James' analysis is focused on, but the nature of activities, and they have changed significantly. It is not always appropriate to look backwards to determine what future may look like. And Mr. James speculates a 33% decline in trade over the next 10 years in his paragraph 5.4. This does not align to current modelling based on discussions that we are having with our customers at Port Taranaki. We're expecting to see liquid bulk volumes lift over the next 2 financial years, following oil field development activity being undertaken by OMV in the Maui A, Maui B and Pohokura licence areas, where significant capital has been spent to access reserves and increase production. Methanex, our largest customer at Port Taranaki, are undertaking a significant plant turnaround right now at their Motunui site and have a desire to bring their Waitara Valley plant back online. Beach Energy are planning an offshore Kupe development well, and Greymouth Petroleum are conducting new seismic surveys within their offshore licence areas. These are not the actions of a sector in steep decline. They are investing in a productive future, likely to see out the next 10 years of the proposed district plan. On the logging front, we are seeing significant port user, ISO, investing capital in the robotic scaling facilities, and I've spoken about those already. But I'd like to also just mention the Move Oceans opportunity, who are investing in 2 new vessels with the intention of establishing 2 new scheduled shipping service routes through Port Taranaki. Move Oceans plan to start a coastal shipping service with the support of $10 million from Waka Kotahi between New Plymouth and Nelson from around March 2023. If this vessel ran continuously, it could visit Port Taranaki up to 4 times per week. Not wanting to seem fanciful, let's assume that they visit Port Taranaki twice a week. They have also announced a new Trans-Tasman service visiting Port Taranaki once per month. Combined, this single new customer could see 116 new vessel movements through Port Taranaki annually. It's a 42% increase in vessel visits and completely counter to Mr. James' forecast used to establish likely noise-making trade activities at Port Taranaki. The coastal vessel service will require a staging area, and that's the staging area that I referenced, and that you can also see in my appendice, directly to the north of the Seaport Land Company, which is Appendix 2 of my evidence in chief. My point is that Seaport Land Company site, if rezoned as to mixed use, will be an island in amongst a very busy port zone and industrial zoned environment with circa 15,500 truck movements through the new ISO scaling facility on its back doorstep. And of course, the coastal vessel marshalling area at its front. I now want to focus on non-port land ownership within the port zone.
Ross, just a question about the roll-on, roll-off vessels. Are they similar in scale to the Wellington-based Blue Bridge and rail ferries?
It is quite a large vessel. It's got 1.2 kilometres of laneway on it, but I just don't. It's about 130 metres long.
Okay, it's one now. Just make a note of that. 130 metres
In length.
Yes. Thank you. Carry on.
I just want to talk about non-port land ownership within the port zone. So, in my Appendix 1, there's a drawing of land owners within the port zone. So the Seaport Land Company site is not the only land site within the port zone which is not owned by Port Taranaki. If you take a look at Appendix 1, you will see that other landowners include KiwiRail, Magog Motorcycle Club, the Taranaki Regional Council, and Methanex. They also have property over which Port Taranaki does not have any control within the proposed port zone. Now, in terms of port land strategy and opportunities for growth, I illustrate in my evidence and in previous submissions to the proposed district plan process the ever-changing nature of trade. This goes to a key port strategy regarding the land that we have. It is Port Taranaki's strategy to ensure that we are able to facilitate future trade opportunities by supplying land to support them. In particular, there are a number of facts that point directly to a new offshore wind sector gaining traction in New Zealand. And I think I've covered that already. This is a 30-plus year industry employing thousands of skilled workers over its economic lifetime. At the previous hearing, we saw some very interesting concepts presented by Mr. Marlow. In them, we saw the Eastern Reclamation Area hosting a marina with public access.
Sorry, Mr. Dingle, just to orient you, Mr. Chair, he's reading from the second main paragraph on that page, beginning yesterday. We saw
Yes,
some.
yes, gotcha. Thank you.
Reclamation area hosting a marina with public access as part of the live, work and play vision of Seaport Land Company. Port Taranaki's vision for this land is to be supporting offshore wind as a laydown area for wind farm components and a possible operations and maintenance base for offshore wind farm owners. Port Taranaki sees the 18.8 hectare former New Plymouth Power Station site as a potential base for producing green hydrogen. It's not that Port Taranaki doesn't have a vision, it's just that our vision for the port zone differs from Seaport Land Company's vision for the port land. Port Taranaki is not prepared to accept that our land requirement is diminishing on Seaport Land Company's speculation that trade is going to decline. We see a bright future supporting our existing customers and enabling our region to remain the energy capital of New Zealand, supplying renewable energy to global markets while supporting the offshore wind sector developed in our region. Now I'm going to go to the social license to operate.
Not to delay this, but if there's a green hydrogen production facility at the old power station site, that would be where the electrolyzers would be and the convert and the tankers. And in your mind, is that an export hydrogen scale? It's not just something to supply New Zealand. It would have tankers heading off into the world commodity hydrogen market.
That's correct. It would be an export scale facility.
And then other port berths and depths of Entrance Way, are they at the scale that would handle the sort of tankers that we've seen?
Yes, they would.
Pitches
Yep.
transporting hydrogen.
The draft would be appropriate. There might need to be some development on the wharves to connect the hydrogen facility to the wharf.
But the length of the wharf and the depths of the wharf.
Port Taranaki is a nationally and regionally significant infrastructure asset and lifeline utility. On behalf of our customers, we trade circa $2 billion worth of product across our wharves annually. We are the third largest bulk handling port in New Zealand and the only deep water port on New Zealand's west coast. We take our social license to operate seriously, including our obligation to operate safely, efficiently, effectively, and in an environmentally sustainable manner, supporting growth and our region's ability to trade with the world. It is Port Taranaki's view that the port zone as notified and the noise control boundaries as notified are important enablers in allowing us to meet these objectives. In conclusion, I support the views of Ms. Carter and the council planner that the port zone and the inner and outer noise control boundaries should remain unchanged in the proposed New Plymouth District Plan, providing an environment in which Port Taranaki can grow and develop to meet the ever-changing needs of the Taranaki region as a nationally important infrastructure asset.
Thank you, Ross. And look, I think it's pretty good that you've sat in on the hearing and produced this extra evidence. We've sort of adopted that style as we've gone along. Yeah, letting people listen and then provide an opportunity to think about and after the heard others. So that's good. Dave, Look, I'll just double check. I think I've covered everything already, anticipating your statement. I just double check back on my reading from chief, but I didn't have anything else. So there's questions. No, I've all got. David, do you have any questions for Ross?
Yes, Stephen, I have 3 questions for Ross. Mr. Dingle, the first question relates to the roading pattern that you referred to, particularly the access ways. Can I just understand, I'm sorry about the pronunciation, Hakarau Street, is that the main access road to the, yeah. I can see that on your appendix 2 to your 26th of July statement. It's just almost off the page there on the top left-hand corner. Is that correct?
It's correct. It's correct.
Yes. And is that legal road, Mr. Dingle?
I believe that is a legal road, yes.
Yes. So that has a formed intersection with Breakwater Road, which is the, correct me if I'm wrong, which is the state highway, is that correct?
That's correct.
Yes. State Highway 3?
Sorry, can you repeat that?
Is that State Highway 3?
State Highway 43.
43.
45, sorry, State Highway 45.
Thank you. And then you referred to, I wrote it down, sorry, I can't find it. It was the road that was associated with the roll-off coastal vessel truck marshalling area.
Yes, so that is also in Appendix 2.
Yes,
it's highlighted red.
Yes, I see that. You had a name for it, and I just can't recall what you called it.
Refinery Road.
Yes, Refinery Road. Thank you. Does that have legal road status, or is it privately owned port land?
It's privately owned port land.
Yes. And the intersection, well, sorry. And so presumably it was all that road that entwines to the north of the seaport site and to the east of the seaport site, as shown on your appendix 2.
That's correct. On the northern side of the Seaport Land Company, Refinery Road, which intersects with the east gate of Port Taranaki, and it moves up the hill along the frontage of Seaport Land, and then into the main car park of the Port Taranaki office.
Yes, I see that.
And in fact, some of the land in behind the office is also Port Taranaki land.
Yes.
A small section of land directly north of the railway belongs to Kiwi Rail.
Okay. Thank you. I'll move on to my second question and the third one, and they're both related. The first relates to the Taranaki Regional Council's 2020-21 annual monitoring report that Ms. Simpson referred to yesterday. Are you familiar with that? You're familiar with that document?
I'm familiar with the document, but I don't know the intimate detail of that document.
Okay. Ms. Simpson's position was that annual report, and that's the most recent one, that at the time of inspection, the dust from the port was compliant with the relevant provisions of the Regional Air Quality Plan for Taranaki, and that no further action was required. Was the port advised of that position by the Regional Council? Did you receive a copy of the report?
Port Taranaki does receive a copy of that report.
And I mean, I think you're the commercial manager, aren't you? As the commercial manager, do you endorse the findings of that report?
Yes, so as the commercial manager, I have various interactions with other people at the port, including the environmental manager. That sentiment would be aligned to his sentiment.
Yeah. Although in your supplementary brief, you did indicate, I think, that there are from time to time complaints received by the port in relation to matters such as dust nuisance.
That's correct.
Okay. The companion and my final question to that is from a noise perspective, which is a district council jurisdiction. Are you aware of any similar or comparative annual monitoring report undertaken by the district, by the city council, I should say, district council, in relation to noise as compared to the regional council one with dust?
No, I'm not aware actually that they provide a report like that. I haven't physically received or seen one.
Okay. But similarly to my question to you about receiving dust complaints, the port does receive noise complaints from time to time.
That's correct. And in fact, Ross Lilly at the New Plymouth District Council will phone me to discuss noise complaints that councils receive directly.
Yes. Has there been any occasion for the council to take any abatement or enforcement action in relation to noise from the port?
Not in my time at the port, which was 3 years.
Thank you. Okay, that ends my questions. Thank you. Thank you, Mr. Dingle. Thanks, Stephen.
Thank you, David. And I think just a bit of a supplementary on the complaints question David made. I just look at your evidence, Ross, and you say each time Port Whiringi has been complying with that consent conditions and other regulatory obligations. So does that apply right across the board in terms of regional council and district council responsibilities? Like you mentioned the noise, no abatement or enforcement actions in the time you've been there.
That's correct.
So you're not aware of any others previously?
There has been notices received. Once again, I'm swimming outside my lane a little bit here, but for bark getting into the water. But
Okay.
but that's quite different from what we're talking about here.
Understand. Thank you. So, thank you, Ross. You're now finished in terms of questioning.
Thank you.
So we'll just slip into this table here if we can, just to now. Christine, I think you like these are the copies here. So yeah, oh, you've already had that. Well, that makes me get Christine has. So just to explain, it's supplementary is going to read out. This is the just because this is the final time Kath turned up. Just the final version of the plan provisions and the changes she's made, which relate to the topic about centres and so on, and the things you asked her to follow up. Highlighted in yellow, and she'll just bring those to your attention when she goes through.
Thank you. We're looking at the colours.
I really was, to be perfectly honest.
We've got some really good choices when you move along the main colours.
That's not.
Okay. I'm sorry about that. I didn't know. That's good. It's not want to do it behind us.
And I have asked that Kath take you into that document just to show you where those yellow bits are and just so you can see them for yourselves.
Right.
Yeah, let's rock and let's start at
Let's
paragraph
rock into it.
4, Matt.
So starting at paragraph 4, so prepared this reply evidence relying on the supplementary evidence of Mr. James. dated yesterday, and the memorandum provided by Tim Heath for the NPDC also dated yesterday regarding the economic impacts of the proposed rezoning of the seaport site. Mr. Jones and Mr. Heath given to the evidence in response to a direction from the commissioners requesting they address the matters listed at 5A and 5B, and we're quite familiar with those, so I won't read them out again.
Yes.
Additionally, during the hearing yesterday, I was asked to provide a map showing the notified medium density residential zoning in the proposed district plan that lies between the OCB and ICB, so that is attached at Appendix 1. I was asked to update the proposed provisions for the Ngā Motu Marine Precinct in response to the matters raised during the hearing yesterday, and provide my expert planning opinion on the economic evidence referred to above, including consistency with the strategic objectives in the proposed district plan, and commenting on the section 42A addendum provided by Mr. Wesney. So we have the map there. I think that's reasonably self-explanatory, and I hope that does the trick to.
Thank you. It does. From my reading, we'll hear the hand go up. Otherwise,
Excellent. So
here we'll see the hand go up. Otherwise,
looking good. Amendments to proposed provisions, paragraph 9. So I say attached to appendix 2. I've actually separated those out as a separate pile of paper so that we can look at them concurrently. And I'll just work through the changes from paragraph 10. So the first one there is a change on page 1, highlighted yellow. So I have added the hierarchy of centres in the district, the list of matters provided for by the specific design and activity controls in the precinct. If we flip to page 7, NMM precinct R1, rule R1 has been amended to reflect the recommendations of Mr. Heath. So the financial and insurance services, administrative support services, and public administration and safety are now excluded from the permitted activity rule for business service activities. So I just worked through the exercise of comparing those activities to the definition in the proposed district plan, and they all fit within that. So that rule is worded now then makes those sorts of activities non-complying within the precinct. Under that same rule, other business services activities will remain permitted subject to compliance with the ethics standards. Moving to D, in my reply evidence, I'd inserted a second matter of discretion adjacent to each of the R1, the rules R1 to R10, and that read, an assessment criteria over the extent and effect of the activity on the role, function, and predominant character of the city, local, and town centres. So that features throughout those rules 1 to 10. This wording was inserted at the recommendation of Ms. Marco, which I agreed with. We did need an assessment criteria to that effect. However, I've moved this to the appropriate effect standards for consistency, because the first matter of discretion in each of those rules refers to any matters of discretion and the finished rule or effect standards. So we're starting to go in circles on itself.
That's why it's shown as crossed out.
Yeah, so that's why it's shown as crossed out. Those rules, and it's been shifted down to the bottom. E, page, so we might read a page 20. Which is NMM precinct effects standard 4, S4, which is our maximum GFA for retail activities. So the total cap, firstly, the total cap of 200 square metres GFA and sub precinct A has been changed to 450 square metres. This is to include the potential for the engine room to be repurposed for hospitality and entertainment activities as envisaged in the master plan, and I'd omitted this by error in my original brief. So in my evidence in chief, paragraph 159, I've calculated that the percentage of the GFA at the site and retail was 6%. And note this additional 250 square metres takes it to around 6.7%. In that same rule, an exception has been provided for marine-related retail activity from the restrictions on retail GFA, which Mr. Heath considers as appropriate in this location. I've amended the wording of the proposed permitted activity standards to make it clear the maximum GFA per sub-precinct relates only to general retail and entertainment and hospitality. And that's more of a consistency thing. It's just because the other retail, the large format supermarkets, integrated retail, are non-complying in the precinct. Still on that same rule, in addition to the maximum retail GFA in each sub-precinct, a maximum GFA in general retail per tenancy has been added as follows. 300 square metres GFA per tenancy in sub-precincts A and C, 300 metres square GFA per tenancy in sub-precinct B, with the exclusion of one tenancy for convenience style retail of up to 1,000 square metres. These limits were proposed by Mr. Heath and are supported by Mr. James. I also note that Mr. Heath appears to support the exception for a grocery type store to service the convenience of local residents and workers of up to 1,000 square metres. As originally proposed by Mr. Heath, proposed to Mr. Heath by Mr. James, in which SLC wishes to have on site. Moving on to F and over the page, a new standard, NMM precinct S new, places a total GFA cap on the combined business service activities, commercial activities, and commercial services activities within the precinct. So that's listed at 1A, and this is consistent with the GFA calculation for the underlying master plan. Mr. James supports this proposed standard, and I understand that Mr. Heath also supports a total cap, subject to the inclusion of the other thresholds, which I refer to below. So in addition to that total cap, a maximum GFA per tenancy of 500 square metres is provided for in the business service activities, reflecting the recommendations of Mr. Heath to ensure that any large-scale office activity is directed towards the city centre. This per tenancy constraint does not apply to any marine sales and service-related office functions, which Mr. Heath considers are appropriate in this location. And lastly, right at the bottom, just a review of precinct S8. This has been amended to make it clear that until the Ngā Marine precinct guidelines are approved, activities are restricted discretionary, with the NMM precinct policies forming the matters of discretion in this case, and to provide clarity in relation to the matters of discretion, depending on which aspect of the effect standard.
It's page 23.
Yeah, that's the last page, 23.
That's the one you raised, Mr. Commissioner.
Yeah, and that's to avoid us hitting a dead end, essentially. So you probably need a bit of time to digest some, and Mr. Wesley might want some time to digest those as well. So I'll move on to response to the 42A addendum in light of the further evidence we received. So during the hearing, it was requested that I respond specifically to paragraphs 18 to 41 of Mr. Wesley's 42A addendum, particularly in relation to the centre's hierarchy. For the record, I note that I responded to Mr. Wesley's addendum report in paragraphs 58 and 59 of my reply, dated 10th of August. I reiterated my view that there will be no inconsistency with the strategic objectives relating to the centre's hierarchy, for the reasons previously set out in my EIC in paragraphs 158 to 167. Because at that time, Mr. Wesley and I had disagreed about the potential impact on the centre's hierarchy, and because nothing in Mr. Wesley's addendum report gave me cause to reconsider my earlier opinion, for sake of brevity, I didn't repeat my earlier opinion in that reply statement. I note that when Mr. Wesley prepared his addendum report, he didn't have access to Mr. Heath's advice. As such, the views of Mr. Wesley expressed in his addendum report may have been superseded by the more recent advice that he's received. However, as requested, I respond to those paragraphs in his addendum report below, including by reference to Mr. James and Mr. Heath's advice and the revised provisions. For the sake of brevity, I focus on areas where I disagree with Mr. Wesley. So the role and function of the port zone and mixed use zone. In paragraphs 19 to 23 of his addendum, Mr. Wesley states that a comparison undertaken between the proposed land use activities for the Ngā Marine precinct and the proposed planning framework highlights a concern in terms of the centre's approach in the PDP. Mr. Wesley was concerned that the activities sought in the proposed provisions were misaligned with the PDP approach to commercial distribution and could increase activities that duplicate the role and function of the city centre. Mr. Wesley was not convinced that the proposed retail activity thresholds, that's the total caps on a per sub-precinct basis, would be effective. In response, I note the changes that have now been proposed as identified above, in line with Mr. Heath's suggestions and supported by Mr. James. I also note Mr. Heath's statement that the proposal represents a unique development opportunity, which will deliver a new environment and destination to the district. And given its waterfront location, be a development not easily replicable or appropriate elsewhere in New Plymouth, which must include the city centre. Mr. Heath identifies that retail is an important component of a waterfront development to provide the requisite amenity for workers, local residents, and the general public viewing the area. In Mr. Heath's opinion, the scale of proposed retail activities is not at a level that would undermine the role and function of the city centre, nor its redevelopment potential over the short to medium term. Mr. Heath notes a number of proposed controls, restrictions on the GFA per tenancy, and discouraging mainstream retail stores such as department stores, large format retail, that are now incorporated in the proposed provisions. Mr. James notes that the larger types of retail may well be excluded by the maximum footprint rules proposed, which will further mitigate the risk of those activities locating on the SLC site. And as we reference back to that evidence there. I agree with Mr. James and Mr. Heath in this regard and prefer their opinion to the conclusions reached by Mr. Wesley in his earlier addendum report. Historic and cultural and tangata whenua. At paragraph 28, Mr. Wesley identifies a potential lack of provisions to ensure the proposal is consistent with objectives HC 1-3 and TW 8-12 within the strategic objectives of the proposed district plan. Objectives HC1 to HC3 set out the historic and cultural strategic objectives, with tangata whenua objectives identified in TW8 to TW12. They place significant importance on the cultural, spiritual, or historical values associated with the site and include obligations under Section 6E of the RMA to recognise and provide for the relationships of mana whenua with their culture, traditional ancestral land, sites, areas and landscapes and other taonga of significance. In response to the concerns raised by Mr. Wesley and Ms. Markle, I have amended the proposed provisions in my reply evidence to include a rule to ensure no building activity occurs until the co-design master plan process has been completed and the proposed building activities are certified by Ngāti Te Whiti as being consistent with the master plan. I understand that Ms. Markle is happy with the proposed approach once the master plan is complete. I maintain that the proposed precinct and associated provisions would be far more consistent with objectives HC 1-3 and TW 8-12 than the notified zoning. Moving on to the natural environment, paragraph 29 of Mr. Weasley's addendum report states that both the notified port zoning and SLC's proposed provisions would be consistent with the natural environment strategic objectives, and in particular NE number 6. I maintain my view that the proposed provisions would be more consistent with the natural environment objectives than the notified zoning for the reasons set out in paragraphs 150 to 152 of my evidence in chief. Retaining port zoning would not provide any opportunity or incentive to improve the natural environmental outcomes on the site, including for mana whenua. Urban form and development, the key strategic objectives that are central to the issues and effects on centres and the city centre in particular are UFD 13 to 18 and UFD 19 and 21. At paragraph 30 of his addendum report, Mr. Wesley states that he considers the nature and scale of development proposed for the Ngā Motu Marine Precinct as inconsistent with the cohesive, compact and structured urban form and development anticipated by objective UFD 13. He doesn't elaborate on this conclusion except to refer to the other strategic objectives in UFD 15 to 18, 19 and 21 as providing further direction on what is anticipated in terms of the above. I will therefore come back to the issue of UFD 13 following consideration of those other strategic objectives. At paragraph 31 of his addendum report, Mr. Wesley considers the proposed rezoning as inconsistent with objective UFD 15 and that the port mixed-use zones are not locations identified in this objective for housing or as living environments, as they're not identified by housing. As they're not identified by housing or living environments. I disagree. I consider proposed activities will provide variety in housing types, sizes and tenures, in a quality living environment to meet the community's diverse social and economic housing needs, satisfying the first part of objective UFD 15. Furthermore, the site is within walking distance of the city centre, with connectivity along the coastal walkway, and it's near on a transport node, and so is located in one of the locations identified under UFD 15 as being suitable for housing. I refer to Mr. Heath's statement during the hearing where he said he did not see any inconsistency with the higher level objectives and policies. I also note that he identifies that, like the Viaduct Basin and Wynyard Quarter precincts in Auckland, the SLC proposal provides the opportunity to better connect the New Plymouth community to the waterfront and promote economic growth and social connectivity. And the emphasis there is mine. He also finds that the proposal would plug a current gap in New Plymouth's market and would stimulate growth in its economic base around the marine sectors in particular. I note Mr. Wesley's comments in paragraph 31 in relation to the proposed mixed-use living precinct. Proposed to the hearings on the mixed-use zone. For the reasons I set out in my primary evidence and supported by Mr. Heath, the SLC proposal provides a unique opportunity for a live, work and play development that is consistent with other similar waterfront developments, which differentiates it from other mixed-use offerings, including the proposed living precinct within the district. And just for reference, that's the proposed living precinct that's around the city centre zone, which has come through that hearing. I therefore maintain the proposal is entirely consistent with UFD 15. UFD 16, 17 and 18 are the strategic objectives which sit behind the council's centres hierarchy. At paragraph 33 of his 42A addendum, Mr. Wesley concludes that based on the proposed plan provisions received in evidence from SLC, the nature and scale of retail, business and commercial activity proposed is inconsistent with the hierarchy of centres sought to be maintained in these objectives. At paragraph 34, Mr. Wesley makes a similar point in relation to the proposed mix of activities as addressed above at paragraph 16 to 20. This is responded to by Mr. Heath and Mr. James. As noted above, Mr. Heath's opinion is that the role and function of the district centres and or hierarchy of centres are not undermined by the SLC proposals subject to checks and balances being imposed. He concludes that the amendments required, which have now been incorporated into the proposed provisions, provide further security that the scale of activities within the proposal will not generate material adverse economic effects on the city centre. Mr. Heath confirmed to the hearing that the proposed activities will be consistent with the higher level strategic objectives. This applies equally to retail as it does to office activity, subject to the limitations on size and type. In addition, Mr. Heath concludes that the proposed activity at the SLC site will provide market demands for its residential and commercial provision that would support the Motoroa local centre. In his opinion, the centres would end up complementing each other to the benefit of the community rather than competing directly with one another. Mr. James agrees with this statement. Mr. James identifies that the overall impact of retail and commercial office activity at the SLC site is likely to be additive to the New Plymouth market, complement the city centre, rather than acting as a substitute for it. His evidence was that while there might be some substitutional impacts around the margins, these would be materially outweighed by the net benefit to New Plymouth from attracting new business and economic activity, and a point Mr. Heath agrees with. Mr. James identifies the additional vibrancy that people living in close proximity to the city centre will bring to it. He concludes that the proposed provisions would further mitigate the risk of substitutional impacts on the city centre. With the additional provisions in place, and as supported by both Mr. Heath and Mr. James, my position remains that the proposal is consistent with UFD 16, 17 and 18. As the proposal is consistent with those objectives, it's also my opinion that the proposal is consistent with UFD 13. The proposal will enable a well-designed and master-planned urban form and a well-connected live-work-play community that will provide social and cultural vitality. The rezoning will add to the diversity of housing stock available in New Plymouth and will be complementary to the city centre zone. As Mr. Heath concludes, the proposal is a great opportunity for New Plymouth, which should be encouraged and facilitated, subject to the measures which have now been introduced. In summary, it's my opinion that the proposal is consistent with the centre's hierarchy. The proposed uses do not undermine that hierarchy, and this is supported by the economic evidence provided by both SLC and the NPDC. I therefore disagree with Mr. Wesley's statements in his addendum report to the contrary, while noting that he may wish to revisit his opinion as part of his right of reply in light of the strong and consistent economic evidence presented. For completeness, I note that at paragraphs 34 and 35 his addendum, Mr. Wesney concludes that the marine focus of the precinct could be appropriately provided for under the notified port zoning. I disagree. The port zone, and particularly the port operational A precinct under the notified zoning, does not allow for living activities, which are a key component of the benefits of a waterfront development, as identified by both Mr. Heath and Mr. Marler. Further, the definition of port activities, see appendix, which I've included therefore in appendix 3, covers only a few of the potential marine activities that are anticipated in a waterfront development, such as this. In response to paragraph 36 and the suggestion that the proposed offering is different to the Auckland and Wellington context, Mr. Marler and I referred to in our EIC. I note that Mr. Heath makes explicit reference to both the Viaduct Basin and the Wynyard Quarter precincts as supporting his opinion regarding the exciting opportunity the SLC proposal provides. While Mr. Heath refers to the Blue Haven proposal in his evidence in relation to cumulative effects, I note that he does not compare the SLC proposal to Blue Haven, nor does he rely on his earlier evidence given in relation to the comparison with the Hamilton market. Finally, I note that UFD 21 requires that airport, port, major facilities and large-scale industrial activities are able to operate efficiently and effectively, and the contribution they make to the economic and social well-being and prosperity of the district is recognised. It is paragraph 40. Mr. Wesney expresses some reservations about the potential for the rezoning to compromise the efficient operation of the port. While not a matter addressed by economic experts, I remain of the opinion, based on expert evidence of Mr. Marler, Mr. Stiles, Ms. Simpson and Mr. van der Munkhoff, that the proposed provisions will ensure that port activities are not compromised by activities on the SLC site, and the provisions appropriately recognise the significance of the port in New Plymouth's economy and its wider role in the community. In summary, I continue to hold the opinion expressed in my EIC that the SLC proposal is consistent with the higher order strategic objectives in the PDP. I also confirm that, in my opinion, the proposal is consistent with and or gives effect to relevant higher order policy documents, including the Coastal Policy Statement and the Regional Policy Statement, for reasons set out in my evidence in chief. In conclusion, I continue to support the proposed provisions attached to my reply evidence, as amended by the supplementary evidence, consistent with the master plan outcome at the SLC site and SLC's vision for a mixed-use waterfront development.
Thank you, Catherine. That's the most clear and coherent speed read of.
How many times did I say
Right. I don't have any questions on that. I do have a question on this access question that's come up. Singles evidence and the fact is the SLC will become an island. So could we have a plan to focus on that? And I think it's probably appendix 2 of Mr. Single's evidence and sheet.
I should note, Mr. Chair, there are in fact 2 plans labelled Appendix 2. And so just for the avoidance of
What
doubt,
activity matters one I'm after?
they've both got that as well.
Well, I think that looking at this, we're probably going to need to look at both of them, but
Yeah.
it's the first one that I really do want to focus on, and maybe we can just make that a bit.
I just want to share it on Zoom.
No, it's the other one, I think. Let's have a look.
Next page. I think.
Next page.
Yeah, that's.
That one. Okay, you've heard the discussion about land owning and also about the fact that this is being thought about as a roll-on, roll-off coastal vessel marshalling area. Have you been at those sorts of marshalling areas in Wellington or Picton, Catherine?
Yes, I have. Yep.
And you know the little tractors that come and go? hook on
Yeah,
to-
they poodle around and they pick up the truck trailers and run them into the ferry, and then they get taken off at the other end.
Yes.
Yep.
I think in my mind, that's what is a marshalling yard, the truck side of the marshalling yard that we see at Picton and Wellington would be a reasonable comparison to this.
Yeah,
Yes.
yeah, I'd imagine so. I don't know if the frequency would be similar. I'm not aware of how frequent this would be, but I imagine it'd be daily.
I think we did have some frequency evidence that it was, might be it's written in your statement, I think.
Yeah, so what I said was the vessel could arrive at the port up to 4 times per week.
Yes,
But for the purpose of my evidence, I assumed twice.
yes. Okay. So look, that's probably not the main issue, but just recognising that that is on port land and
Yes, yeah.
for the reason that Mr. Dingle explained, it's from global planning terms, unreasonable to think that this area might be used for that or would be used for that.
Yeah, and that has been discussed throughout the various hearings in relation to the site, whether it be passenger transport or anything along those lines, utilisation of that road for access in to the port.
Yes.
That's come up.
That's one question. The other one is the correlation of Mr. Marler's 3 access points with the port-owned land and whether you agree that there needs to be a commercial agreement between SLC and the port to implement those access ways.
I would agree that, so the main access into the site is via Hakido Street
Yeah.
at the moment, at that western end. Any other access would either require potentially negotiation with Kiwi Rail, depending on where it is, and Port Taranaki. If that wasn't forthcoming, it would have to rely on that main Hakido Street access point. There have been a number of discussions about that road and the formation of that access over again the various hearings and consultation we've done in relation to the site. And one option is moving it to somewhere more favourable if Waka Kotahi and Kiwi Rail were in agreement with that. But at the moment, that's what we need to work with.
In master planning terms, is the one access scenario floor or fatal flaw in your terms in terms of how you've set up the ABC?
Yeah, I don't see it as a fatal flaw. It'll just probably create more reliance on an internal network for roading.
Yes. What about car parking and presumably trying to away from car parkings where people want to have EVs and
We're
vehicles?
supposed to be riding e-bikes. Yeah, car parking is again comes up a lot with this site. It will depend on the reuse of buildings and things like that. So there's probably a lot to inform it. There is quite a lot of room on there to provide for it. Again, the original consent application showed a lot of the bottom floor of the Scott Gibson building turned over to car parking.
I'm aware of the Ahuriri site where there's a sort of residential, the stack up car parking building, basically back near the railway line. So
Yeah,
it's not unfeasible.
it's not unfeasible, and it is something that's going to have to be fed into any future design work that is done on the site and actually understand it properly.
Thank you for that. David, did you have any other questions? I'll just make an observation. You haven't sort of expanded your zone provisions rather than reduce them in your thinking, but obviously it's just too late to start thinking about how you might make them more efficient from a wording point of view. Just an aside, really.
Yeah, and I can see that that will be something that probably will need to happen in some sort of wash up, because the underlining mixed use, like a lot of the provisions in the plan are moving around a little bit, so it'll need to be tidied up for consistency there to see where all of that lands as well.
Okay, well, I don't think we've got too much opportunity for much more wash up with. Like most of the hearings this week, and we're making decisions in a couple of months, so I have to talk to, depending on where we get the report back from the staff. Right, so David, did you have any questions for Catherine?
Yes, Stephen, yeah, I have a couple of questions, but before I do, I just want to go through a couple of mechanical matters with Ms. Hooper on the attachment to her supplementary, because this is really the first time I guess we've had to quiz you on this, Ms. Hooper. And I just want to be clear that I haven't misunderstood anything. So my understanding is that the Namutu Marine Precinct is a precinct within the mixed use zone.
That's correct.
And on your page 3, those objectives 01 to 07 are all new.
That's correct.
Yeah, and likewise with all of the policies. In fact, all of the provisions are new, aren't they?
In terms of policies, precinct 1 is new, 2 and 3 and 4 highlight the differences between the precinct and the mixed use policies, and the rest are new.
Yes, thank you. Okay, that's fine. Second mechanical question is, excuse me. Sorry. Can you just take me to the relationship between the structure plan being produced and the activity status for any activities within the sub precincts? I thought I heard you say yesterday that that the production or approval of the or existence of the precinct structure plan is a prerequisite to having certain activity statuses, and in the absence of that, there's a trigger to non-complying activity status. And I just want to be sure I didn't misunderstand that.
So that's been captured in NMM precinct R19 on page 16.
Okay, let me just go there because I'm on the screen here. I don't have a hard copy. So page 16, did you say?
16, yep.
Yeah, and it's renumbered R19. Is that correct?
Yeah, that's correct.
Yes.
And so firstly, it's an integrated master plan versus
Yes.
a structure plan.
Yeah, understood.
And so that this precinct R19 basically restricts any building activities on the site, which we thought was the best way to capture the need for the integrated master plan to be in place before that commenced.
Yes.
So the intention would be the integrated master plan would be co-designed with Ngāti Te Whiti.
Yeah, no, I understand all that. That's just the trigger. So the trigger is not to non-complying, it's to add this based on what's in front of me. Is that correct?
Yeah, that's correct. So if that master plan hadn't been completed, then there's some matters of discretion that will kick in at that point.
Sure.
Similarly, if the building activities hadn't been certified, there's a process through that as well.
Yes. Okay, so that's a precondition on all building activities, isn't it? All the other rules relate to activities per se, as opposed to buildings.
Yep.
Yep. And
Yeah,
then
that's correct. And attention. Sorry.
And it's not until we get to the effect standards that we get, I guess, a mixture of activity standards and building standards.
That's correct. And the intention would be the integrated master plan would be developed, and out of that would flow the design guidelines, which come in that S8 effects standard.
Yes. Okay, can we just go to those effect standards now? Let me just scroll down. Okay, so just, sorry. Okay, so S1, so these generally still follow the National Planning Standard guidelines on the mechanical aspects of effect standards, doesn't it?
was my intention.
Yes, yes, not a trick question. It's just me coming up to speed with
Yeah.
that. Yes.
I'm-
So yes,
I'm open to suggestions if I've run foul of the standards anywhere, but
yes.
use the existing work done on the plan as a bit of a template.
Okay, well, you know, the standards are now over 3 years old, so maybe they need to be revisited,
Yep.
but not for this purpose, I suggest. Okay,
Yeah.
so it's the standards that I want to focus on are the ones that you drew our attention to just a few moments ago on page 20.
Yes.
So the standard S4, this actually appeared in your draft provisions in your first brief of evidence, didn't it? But in a different format than the changes that you've shown in yellow are in fact the changes from that.
Yep, that's
iteration.
exactly right.
Yes. So my question.
Yes.
So okay, I understand. I now understand the mechanical aspect. So the substantive question I've got for you is in the 5th of 5th of July iteration. How did you derive the maximum GFAs that used to exist that you've since altered? So the 200, the 1400, and the 850. How were they derived?
That was derived from the master planning work done by Mr. Marler, and I think it was in the appendix to his evidence. There was a table 5.3 or page 5.3, which is very near the end of his evidence.
Yes.
There's a table there which lists the anticipated GFA of the various activities.
Yes. Okay. Thank you for that. I think I can remember that table. I just don't have it in front of me, but that's not the point. I guess what I'm trying to ascertain is, was there any economic or retail distribution component to the establishment of those other than what Mr. Marler as a architectural practitioner was suggesting might be appropriate?
Yeah, I guess Mr. Marler's a waterfront expert. I would say it's probably a question for him to answer.
No. The questions to you, Ms. Hooper, the question is, apart from Mr. Marler's input, was there any retail distribution input into the derivation of those back in that 5th of July iteration? It's just a yes or no question.
Not directly to me, no. I've relied on that table of Mr. Marler's.
Thank you.
And now Mr. Heath's evidence, of course.
Sure. So that brings us to the changes that have occurred since that original evidence in chief, and you've usefully highlighted those in yellow. Thank you for that. And that's seen some changes to the maximum GFA for retail, entertainment, and hospitality, but also some individual tenancy rules.
Yep.
So that, I think that those were first anticipated in maybe in your 12th of July brief, but you've since nuanced those further in the latest one. Again, the same question: where were they derived from? And before you answer, I appreciate Mr. Heath's position on that yesterday, and I'll come to that in a minute. But what was the derivation of those changes in your 12th of August and the latest iteration?
So looking at NMM precinct S4, number one, the maximum GFA per precinct was raised in my previous iteration. We're looking at number two, the maximum GFA in general retail per tenancy.
Yes.
Those are in direct response. Yep, those are in direct response to Mr. Heath's recommendations and supported by Mr. James.
Does Mr. Heath's evidence specifically provide that level of detail? When I asked him yesterday, he indicated that he hadn't
Yeah,
seen the standards, and Mr. Nolan provided a correction that he had been sent them on the Sunday evening by Mr. James, I think. Mr. Heath sort of indicated that we hadn't really dug down into those. So I'm just wondering about the nexus between you relying on Mr. Heath and what's in front of us.
And we just adopt.
yeah, we've really just adopted that, that additional control recommended by Mr. Heath per tenancy. In addition to the original proposal, which had the maximum GFA.
Right.
I
And
can
are you-
see that, I can see those numbers on page 3, is that right? Of
Mr.
Mr.
Heath.
Heath's evidence?
That's correct.
Because he said with those controls, he was comfortable with it.
Page 3, right.
.300 square meters appears in this third paragraph up from the bottom, David.
I'm just trying to see that. Yes. Okay, I see that now. Thank you. Yes, got that. Thank you. That's good to know. I wasn't aware that Mr. Heath had had that opportunity to provide those. So I see the connection now. Thank you for that, Ms. Hooper. And I guess, Ms. Hooper, you're relying on Mr. Heath's assessment as perhaps the only retail distribution expert that's presenting on this matter.
Mr. Heath and also Mr. James, of course, has reviewed that and provided his input as well.
Yes.
There seemed to be strong agreement between the two of them.
Okay, understood. Okay, my last question is a bit of a change of tact, and I think it's one I signalled when we first convened the hearing, and that is I just wondered what the impact of other district-wide provisions, particularly the coastal environment overlay, might have on all of these provisions. Have you managed to give some thought to that?
I have given some thought to that, and there are a number of extra provisions that do apply, and that the coastal environment is one of them. So we're not objecting to any of those rules. We'll be subject to those rules as per the notified district plan. Similarly, the SASM rules, of course,
Yes.
place significant controls or restrictions over this site, and it's not intended to try and circumvent any of those, for want of a better word. So we'll be working within that framework as well. And additionally, around there we have the waterways, notable trees, and of course our public access corridor running alongside the site. So the intention is to work within that. We have reviewed the intent of the precinct alongside the objectives of those different those district-wide matters in the plan, and don't see any conflict.
Okay,
Yeah.
thank you. I've just noted down those inventory of other rules, so appreciate that. Just for the record, the coastal environment overlay does extend over this seaport site.
Yes, it does. Yes.
Okay, yes. The reason I asked that question back on day one was the port had requested some cutouts or carve-outs from the coastal environment rules to enable it to operate because of the strong avoidance and protectionist approach of the coastal environment rules. And they cited, I think it's policy 9 in the NZCPS, which provides a basis for that for port activities. It may not be policy 9, but it's around there.
I think it is policy 9.
Okay, thank you. And I'm not sure whether the officers have landed on the ROR. I think Mr. Steiner might be involved. But I think there was a recommendation in front of us at the ROR that be adopted, but that the policy framework still apply from the coastal. And the question I have for you is that you're not seeking similar carve-outs or cutouts, are you, for the precinct site?
No, we're not.
Okay. Have you actually had a look at what the effect of the coastal environment rules might be in terms of a bundling approach in terms of activity status?
Bundling, yeah, I think we would get to discretionary or restricted discretionary.
Yeah, taking account of the coastal environment overlay.
Yes, I'd need to double check that.
Okay. Well, I might pose that question to Ms. Carter and to Mr. Wesney also, just as a forerunner. Thank you, Ms. Hooper. Thank you particularly for taking me through the mechanics. I'm just been struggling a little bit of late, so that was a really useful exercise from my point of view. And also thank you, Chair, for directing me to Mr. Heath's page 3. I completely missed that. That's all from me.
So,
Thank you, Catherine. You, Morgan.
Thank you. So we obviously have Ms. Carter to come, and I'll just signal right at the front that these are a revised version that she hasn't seen prior. So to the extent that she can comment on any of those, there may be some limits.
I think in this circumstance, I'm happy to providing an additional, because it's just come in just before you're in time to make any additional statement. Catherine was working overnight, and I wondered whether by the end of the week, if you could get in anything additional about the mechanics of the wording as a supplementary statement. Janice, if that
That'd
would
be really helpful. What I thought, my summary of my evidence is quite high level, whereas this is quite detailed.
yes.
And I do have some comments that I could give you now, but I would really appreciate the opportunity to go through what Catherine has given us today,
Yes.
particularly that assessment of the strategic objectives, which I haven't seen.
Yes.
And also the provisions. I do have some concerns about the provision. And I think if you're contemplating the rezoning, which you may be, I had some concerns about the provisions that would need to be ironed out if you were going to adopt them. So, and I think I've heard from and yourself that you've got concerns as well. So how we go about getting those issues resolved if you were going to contemplate the rezoning.
Catherine certainly bounced off the late running retail economic evidence, and providing you the same opportunity is entirely fair in my view. So
can I just clarify for you?
yes,
I totally understand that for the economic
yes,
material.
yes,
The rest of that document was available well ahead of today. So it's commenting on, as I see it,
the yellow.
by the end of the week is the yellow bits. Yeah.
The yellow bits and the economic evidence and the planning conclusions that Catherine's made in her evidence. Now, I think that's clear and fair. And is by the end of the week okay, Janice?
I think so. There's not a lot of yellow.
Yes.
There's quite a lot of analysis in here, but
Yes.
I think I can
Thank
think of
you.
those.
Okay.
And just before I start, in terms of the provisions that you've just looked at them, I mentioned that I do have some concerns about provisions. So before I get to my overview, and McMahon has already identified some issues, and one of them is it is in the yellow wording, and it's marine related retail activities. I can't find any definition of what that might be, so I'm concerned about how you drop off, with the exception of marine related retail activities, how you drop them off from the general definition of retail and entertainment. So it's just highlighting, that's one thing I'll probably provide in my supplementary. The other issue is to do with the change that's being made to the integrated master plan as a condition of permitted activity status. So that's page 16. And I do have concerns about the threshold for permitted activity status being derived through this type of law where it's Ngāti Te Whiti that's certified. And I'm just wondering if there's a co-designed process, where does the council as local authority get to say that the permitted activity status is being complied with? So there's here it seems to rely on agreement between the SLC and Ngāti Te Whiti. And I do have a bit of concern about that process for a permitted activity type rule.
The borrowers of it or the process?
Well, it's in determining a permitted activity, it should be quite clear whether you are permitted or not. And when you've got it set up that it's certified by a third party, I'm just wondering how that provides clarity whether you're permitted or not in terms of the council's administration of its plan.
Well, I think if you can ponder that and give us any suggestions.
I'll have a look at that for Friday as well. And then the other one, and it could be just a matter of Seaport Land Company clarifying it for me, is the wording of the noise complaints covenant. Where's that one? Find it.
22.
Which page? 22. On board. And so,
That's yellow, so let's get this clear.
okay,
Have you seen this before you did your evidence?
the original, yes, I would have seen.
Okay.
So, you don't want me to comment on concerns I have with this?
Well, I think there's an issue about sort of order of betting.
Okay.
And if you've seen all of this except the yellow before you wrote your evidence, which I think is your answer,
Yes.
yes, your evidence was the time to raise concerns.
Well, at a higher level, we've indicated concern with the no complaints covenants.
Okay.
And this is a way of getting it into the plan provision that we're not happy with in terms of planning. So if you are prepared to hear what I have to say about the no complaints covenant, because we're not happy with that process.
You've raised it clearly in your evidence.
Yes, I do.
You're just expanding on that.
Yes, but while I'm here with the provisions, I thought it would be useful to talk about it right now.
That's acceptable.
Yeah. So again, it's a standard, which means that all standards have to be complied with in order to be the standards. And really, it's an issue of clarification. A says no complaints or others, no complaints or other similar land covenant or land legal mechanism is in place over the land and or leasehold and or unit title, in which the land use established to protect Port Taranaki, Kiwirau, Whakatukahi, from complaints about noise, dust, odour, vibration, light and smoke. And it B says the terms of the no complaints covenant are included in any short or long-term lease, tenancy or occupation agreement by occupiers of the building who are not owners of the land. And what I'm concerned about is because this rule sits as a requirement for permitted activity status or other activity status elsewhere in the rules, how do we determine B has been complied with if it's a later occupier? Is there a mechanism that the council can be clear that there is a mechanism in place that will enable future occupiers, not necessarily the landowner, but a future occupier to have written into their lease agreement that they're not allowed to complain about noise? And how does that determine activity status now when they go to build and put in their applications for a building consent and resource consent? How do we get to the place of saying, yes, that's complied with before consent is issued? it's just something I find difficult to get my head around as to how it can be used as a permitted activity condition.
Must say my head's spinning a bit by what you're saying.
It's just and I'm raising it for clarification because this one has to work if it's going to be put in here. And I'm not sure if it does.
I think the way to deal with this has been raised and we'll let Hamish respond to that in his verbal and then written right reply. I think that's the correct thing to do.
I understand what Ms. Carter's raising now in terms of the issue.
The other issues of a general nature I'm about to go on to, I just wanted to draw attention to the definition of port activities, which Ms. Hooper has already done. She has it as appendix 3 at the back of this. So there's a clear definition of port activities. The list is very, very long, and I do indicate this in my evidence that if the site is not used for development, then port activities definition is extremely wide, and there's a lot of activities that can occur on that site. If you look at appendix 3, very helpfully, Ms. Hooper's got that there, so I shouldn't need to read out. But it also includes the question that was asked earlier about the port administration.
Yes, I see those.
Is on that list as well.
Yes.
Yeah.
But
So-
I suppose what I was after that is not only the port administration office, it's pretty large. Building, it's got lots of other tenants, so I presume there's a resource consent for that in place.
I couldn't confirm, but I can do that if you wish. Yeah, whether there's consent, but given the very wide range of activities, it includes industrial activities, processing, blending, offshore production, warehousing, refueling, storage, servicing, port administration offices, marine-related trading industry, commercial fishing. Just the list is extensive, and I think that it's a generous definition in terms of the types of activities that could occur on site. I think that through the hearing, questions been asked, well, what else could you use the site for? In my view, there's a lot of activities that you could use the site for.
Perhaps if we can come back to me on that, because that goes to the heart of the strategic objectives about keeping officers. It's a past thing, so it's not really something determined, but I'm just interested in the text of that. Yes. So maybe by the end of let us know how that occurred, and probably back in some time.
The length of it, the variety and range of activities that are in the.
No, I'm asking about the port administration office.
Oh, yes, okay.
The consent. Yes, just the consent.
And just thought I would also highlight the definition of port mixed use commercial, recreational, and community activities, which is the main defining words for the port's own mixed use zone. So straight under port activities in the definitions, there's another definition: port mixed use commercial, recreation, and community activities.
So just to be clear, this is not in appendix.
No, it's
Three.
on appendix 3. So in the plan.
Another definition, give me the name.
Yes, and it's relevant here because we're looking at a mixed use. The port has part of its precinct E, which is a mixed use.
Yes, it's
And
one.
what confines that range of mixed uses is this definition of port mixed use commercial, recreation, and community activities.
Can you slow down a bit? Sorry. Port.
Port mixed use commercial, recreation, and community activities. And it's directly under the definition of port activities in the interpretation section of the plan.
Thank you.
And I mentioned that because of paragraph 38 of Ms. Hooper's evidence, which I will also respond to providing in terms of the supplementary.
I think you can reply to the new evidence we've heard, the yellow stuff,
Mhm.
and the economics. But you can't give them a rebuttal on anything else. It's not
It was
reading
the
away.
supplementary. It was paragraph 38 in the supplementary.
This is the one that we just had today.
Yes.
We're not saying you can't put a rebuttal evidence on in the plan process. That is other than the yellow highlights. And also the new evidence, we've heard the new technical evidence of effects from the economic people. Otherwise, we just keep going on and on and on. I'm not going to allow that.
Okay, just to so clear, so in terms of the new analysis here on the strategic objectives,
Yes,
am I allowed to comment on
Yes.
those?
yes.
Fine, okay. We'll just get my summary. I'll just read out my summary. So I'll skip this paragraph. In higher order documents and planning framework. So the key relevant higher order documents are discussed in detail in my evidence of chief. They are the New Zealand Coastal Policy Statement, Taranaki Regional Policy Statement, the proposed regional coastal plan for Taranaki, interim version, and the PDP strategic directions. Also relevant to this hearing are the proposed plan, port zone objectives and policies, and the proposed plan mixed use zone objectives and policies, and EB management plans. The proposed plan is required to give effect to the New Zealand Coastal Policy Statement and the regional policy statement, and to not be inconsistent with the relevant regional plans. The officer's right of reply in respect to the strategic directions hearing states that the strategic objectives are overarching and chapter objectives are required to be read and achieved in a manner that is consistent with strategic objectives. I agree with this assessment on the role of strategic objectives.
Sorry, Mr. Chair, could we just do a quick sound check? I'm conscious that Carter has a quiet voice, and just want to make sure that coming through to those who are online.
Can someone on the wall just give us a sound check? Jacob or?
Message Jacob, and he had said, because I did have that thought, and he said.
I can hear fine.
Okay.
Yeah, I can hear fine.
Okay, all good. Thanks. Thanks, William.
In addition to the above, and in response to the evidence of Ms. Jenny Simpson, I also considered the following regional plan to be relevant. The Regional Air Quality Plan for Taranaki. The relevant policy is Policy 2.5, reverse sensitivity, and that's provided in Appendix 1. Port Taranaki is identified in the proposed district plan as significant infrastructure for the district, particularly in terms of the role it plays in facilitating access, trade, tourism, and economic activity locally, regionally, and nationally. It is also recognised as regionally significant infrastructure in the regional policy statement and nationally important infrastructure in the NPS UD. Higher order planning instruments recognise that ports have a functional and operational need to be located within the coastal environment and coastal marine area, and I consider it appropriate to continue to provide flexibility for Port Taranaki to change and grow in its existing location to give effect to Policies 6 and 9 of the NZCPS. Policy 9 focuses on ensuring that development in the coastal environment does not adversely affect the efficient and safe operation of ports, while Policy 6E explicitly states that consideration be given to how built development on land should be controlled so that it does not compromise activities of national and regional importance. There is no certainty that the proposed residential component of the SLC proposal will not result in reverse sensitivity effects from Taranaki. The key policy in the RPS, in my opinion, is INF Policy 2, and is outlined in paragraphs 47 and 49 of my evidence in chief. This policy requires that the adverse effects of subdivision, use and development on the safety and efficiency of infrastructure of regional significance will be avoided or mitigated. There is no additional wording that might soften this policy, such as far as practical, seen in INF Policy 1. The choice is avoid or mitigate. None of the mitigation proposed by SCL adequately mitigates noise, visual effects, dust and odours, for example. There is potential for Port Taranaki to experience reverse sensitivity effects, and this could affect the efficiency of its operations and future development potential and its choices. Acoustic insulation of indoor areas, for example, is not a complete solution to noise effects. Complaints from apartment owners or occupiers are still likely, including when outdoor areas are used or windows are opened. I consider the same will be the case for odour and dust.
Dennis, what evidence are you relying on for your first evidence of paragraph 10?
The looking at Ms. Simpson's evidence, she outlines in terms of dust, for example, and odour, she indicates that there's a need for no complaint covenants, which I don't believe to be effective. The mechanical ventilation is useful for when the windows and doors are closed, but when they're open, there's no mitigation. So it relies on that engineering solution. So I'm saying that it's not adequately mitigating. And there was a third one, which
But visual effects, what evidence are you relying on for that finding?
Pardon?
Visual effects statement?
Oh, so the visual effects statement is really, we haven't really covered visual effects in terms of this particular hearing, but in my experience with other boards, buildings, containers, etc., that go in front of buildings are often complained about. So what I'm saying is that that's going to be something.
Okay, you're a planner, with respect. I'm a planner. I can only make decisions based on evidence on this plan. What evidence are you relying on for your statement there?
Yeah, no, I have to admit that I'm not relying on evidence per se. I could throw that the other way and say that we haven't really heard from SLC as to how they're going to mitigate those sorts of things.
Let's just carry on. You're the start of paragraph 11.
SLC's proposed mitigation, including no complaints covenants, do not provide mitigation for noise effects and do not greatly assist with reverse sensitivity effects. As per my evidence, Chief, while no complaint covenants alert potential purchasers to the potential adverse effects of living in a port environment, people will still complain. Concerns in relation to this cannot readily be managed using existing and well-understood methods, including design controls and covenants. The presence of residential apartments in the proposed rezoning is provided for in the PDP. Has the potential to affect the operation and long-term viability of the port over time. Port activity and residential activity in close proximity to each other are, in my opinion, incompatible. Policy supports E5, paragraphs 97 of my evidence. The Chief supports this view. Submissions have been heard during the hearing in respect to scope, and it is generally accepted that the submissions of SLC has been refined to request rezoning to a bespoke tailored version of the mixed-use zone. The reporting planner in the section 42 addendum provides a table outlining a comparison of the PDP mixed-use zones. As per paragraph 146 in my evidence to the Chief, I do not consider that mixed-use zone provides for residential activity as a permitted activity. In my opinion, the land use planning framework in the PDP and prior order planning documents indicate that it would be more appropriate to not rezone the SLC land in the manner sought in the first place. Port noise. I do not support introducing new land use planning zones for noise sensitive activities within the 55 dB LDN contour. I agree with Mr. Fitzgerald that 55 to 58 is a moderately compromised noise environment and indicates a higher likelihood of reverse sensitivity noise effects. This level is also current. It does not take into account any potential future increase in port noise within the port zone. Mr. Fitzgerald has predicted potential noise levels from port activities to 2035 and has concluded the existing noise control boundaries are in a suitable position. These boundaries will maintain the balance between PTL operating effectively and efficiently and give flexibility for future development opportunities, but also enable noise emissions to be appropriately controlled.
Janice, you've cited Mr. Fitzgerald's opinion. Have you also looked at and considered the expert evidence of Mr. Stiles and Mr. Lloyd on this matter?
Yes.
Yes.
So yes, I have looked at that, but the 55 to 58, I think is agreed that that's the current noise level by all the noise experts.
But we've also heard that you can clearly distinguish between 55 and 58, and the 55s. This is what I've certainly heard from the other. So the question really as a planner, have you looked at the expert evidence in the round? Were you just favouring Mr. Fitzgerald?
Well, I've looked at all the non-experts evidence,
Mm.
and I would say that I am favouring Mr. Fitzgerald. Yes.
Thank you. Thank you, Ed.
At paragraph 128 of my evidence in chief. In paragraph 128 of my evidence in chief, I discuss Ms. Simpson's evidence that the seaport development would increase the sensitivity of the receiving environment due to an increase in the number of people living within 300 meters of dust generating activities. Ms. Simpson concludes that the change in sensitivity is modest due to the presence of existing sensitive activities at similar, slightly lesser distances. I understand from the hearing that this statement is made ignoring any potential mitigation measures. At section 9, Ms. Simpson outlines those mitigation measures. In my view, none of those mitigation measures proposed will effectively mitigate the effects of dust and odor generating activities on occupants of the proposed apartments. Hazardous facilities. I accept the evidence of Ms. Shepherd at paragraph 23 of her evidence. That the process of reviewing the risk management contours of GPL's other well sites provides increased confidence that RNP4 does not present an unacceptable risk to the activities proposed on the SLC site. I also agree with Ms. Shepherd's conclusion at paragraph 31 in respect to the TPC well, and that's in respect to the certification and the plugging of the well. Conclusion. The SLC rezoning proposal to provide for new residential apartments in proximity to Port Taranaki does not give effect. That's Policy 2 of the Taranaki Regional Policy Statement and does not align with strategic direction's objectives. Overall, the proposal is not the most appropriate to achieve the purpose that I made. Residential activities in this location are likely to give rise to reverse sensitivity research on Port Taranaki. Higher order documents and the PDP port zone policies give the commissioners the opportunity to confirm that this SLC site is not the most appropriate location for this activity. I further consider that policy MUZP2 places boundaries around residential activities such that they are not permitted activities. Given the discretionary activity status of residential activities in the mixed use zone and the non-complying activity status in the port zone, it is my opinion that the proposed zoning and provisions provided by SLC for permitted residential in this location.
Okay, look, I'll come back to the theme I was asking you about in terms of effects assessment. In your paragraph 18, you give your opinion about the air effects that Ms. Simpson talked about as an expert yesterday. Paragraph 1.5 gives evidence to us that the proposed development, she looked at the mitigation measures.
Yes.
3 of them that she did A, C, or 3
Yes.
together.
That's 3, yeah.
And her expert opinion as a air quality expert is that given those mitigation measures, the proposed development would not materially increase the sensitivity of the receiving environment. I mean, I questioned her on a scale of 10, she said, not a wouldn't, it's a sort of in the 2 out of 10 basis. So that's her expert opinion. You've given us an opinion as well. Is that based on your qualifications or experience, or what is that opinion based on, that last
My opinion
sentence?
is evaluating the evidence that Ms. Simpson has given us.
But that's not your job to evaluate. It's our job. Our job is to receive expert evidence from experts in the realm of their qualifications, experience, expertise under the code. So I'm just asking you, what?
Well, I've taken her expertise as an air discharge person and evaluated it as a planner.
Missed the point. You're not an air discharge expert.
No, I'm not. And I'm not
And you
trying to
haven't-
be. Yeah.
So you've got an alternative view to Ms. Simpson on this subject, but as a planner, not an expert.
What I'm talking about is, does the level of mitigation that's been provided through the lens of the choice of avoid or mitigate. Is the mitigation that's been proposed at the level where we're saying it's going to mitigate the effects on Port Taranaki in terms of reverse sensitivity? So that's why I'm saying what I say at paragraph 18, because I'm looking at this level of mitigation that's required in order to give effect to the higher order documents.
Right, David, do you have any questions for Dennis?
Yes, Stephen, I have two. Good afternoon, Ms. Carter. On the first question that is on the issue of reverse sensitivity, that sort of takes the lead from the chair's questioning to you. When you talk about reverse sensitivity in the round, are you consciously dividing that into noise and air quality matters, or are you putting them both on an even keel in terms of the potential to cause reverse sensitivity, and I guess then the potential to either not mitigate or not avoid the effects on the operation of the port as outlined in the high level document policies and objectives that you referred to?
If I take your question, can we separate out all the various effects, dust, noise, odor,
Yeah.
and are they all on the same level?
Yes, not only
No,
not,
I
only,
would-
not only that, Ms. Carter, but can we and have you elevated one of those potential reverse sensitivity effects, e.g. noise, over and above dust, or are you treating them equal in the round?
I think that noise tends to be a bigger issue for ports generally.
Yes.
Dust and odor are also issues, so I wouldn't, they may differ from day to day in a port. So some activities may result in noise being the bigger issue, and some activities such as the PKE may result in odor being the key issue. So I find it difficult to answer your question because they're all potential
Well,
effects that could give rise to reverse sensitivity.
right. Well, that in itself is an answer. So if that's your answer, that's fine. In terms of the evidence you rely on, are you able to draw more of a causal nexus between one of those reverse sensitivity effects than the other?
Could you explain what you mean by
Is
that
there-
question?
Well, we've heard evidence from Ms. Simpson on dust and odor. I don't know that we've heard any evidence from any other expert on that field, but my memory is not what it used to be. We've heard contested evidence on noise. So I guess what I'm putting to you is that the evidence on dust and odor, unless I've completely had a mind blank, is largely uncontested at a technical level. But at the noise level, clearly there's a contest between Mr. Fitzgerald and Mr. Rowe and Mr. Lloyd. I'm not saying that they're all in disagreement, but we've at least heard from 3 witnesses in that sense. And I just wondered how your planning evaluative evidence, opinion evidence, has reflected that.
So in terms of, I'm relying solely on Ms. Simpson as the expert in terms of dust and odor, because that's the only evidence that we have. But with respect to noise, I've looked at Mr. Stiles, Mr. Lloyd's, and Mr. Fitzgerald's, and I have preferred Mr. Fitzgerald's, though stating that there's not a lot of disagreement between the noise experts. It's more to do with the finer detail of the location of the inner and outer control boundaries that the disagreement lies.
Yes. I don't know if you can hear me still. The screen in front of me is just frozen.
Yeah, it's frozen for me as well.
Stephen, I'm not hearing anything or seeing anything at the moment. I'm not sure if anyone else is in that situation. Good afternoon, everyone.